She walks it loud like a thunderstorm, debunking myths with style and form. True crime, conspiracies her game. Melissa Jade, remember her name. She's loud, feisty, spilling tea, diving deep into mystery, breaking down your wildest claims. Melissa Jade, she's got no shame. Microphone fierce like a roaring lion, unveiling secrets people been hiding. True crime queen of the digital scene, Melissa's got you hooked on her screen. She's loud, feisty, spilling tea, diving deep into mystery, breaking down your wildest claims. Melissa Jade, she's got no shame. Murders to cover-ups, nothing misses. Melissa's here to share her guesses. She's got theories big and bold, no stone unturned, no case cold. She's loud, feisty, spilling tea, diving deep into mystery, breaking down your wildest claims. Melissa Jade, she's got no shame. Melissa Jade, she's got no shame. Melissa Jade, she's got no shame. From murders to cover-ups, nothing misses. Melissa's here to share her guesses. She's got theories big and bold, no stone unturned, no case cold. She's loud, feisty, spilling tea, diving deep into mystery, breaking down your wildest claims. Melissa Jade, she's got no shame. 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 She's loud, feisty, spilling tea, diving deep into mystery, breaking down your wildest claims. Melissa Jade, she's got no shame.
Hi, everybody. How my shaving day?
Hey, MJ, everybody.
What's cooking good looking?
Not much.
I am so excited to do. I couldn't wait, and I'm so happy that you're on because I'm so excited to do this second part. I'm scoping out the chat though. Like, do I see Harlot yet? I don't see her. I saw Harlot all the way here at 8:30, and we need Harlot because I don't think she didn't go through all these motions yet. She waited for us.
Also,
Hi, Morgan. Hi, Allie. Hi, K-Braze. Hi, Daryl Smith, Hippie Chick, Angel D, Fragile Like a Bomb, Christy Schick, Kelly. As I cracked open a jar of ragu tonight for dinner, I thought to myself, MJ would slap this out of my hand and onto the floor if she were here right now. Yes, I would. And I'm happy that I'm or conscious in the back of your mind telling you no ragu. Come on. Tomato sauce is so simple. But if you're going to go for it, go for like Vincent's. Go for I don't really like Prego myself, but like you could go for a jarred sauce and not have it be ragu. Ragu is ketchup. It's the worst form of jarred sauce. You know what I mean?
yeah.
Here with dots in hand, that's my girl. Hi, MK. C. Carter. Taz. K-Braze. Hello. Are you ready? So let me just pull up our missing child. And I was like, oh, okay, I've never done this missing child before, but I had to look at the name ahead of time, and I'm already going to tell you I am not going to get this accurate, but I'm going to do my best. Hi, Terry Ann. So this is Vitalia Yarovitskaya. That's the best I could do.
That's about what I would do too.
Okay. Missing since April 8th, 2019. Look how adorable she is. From Virginia Beach, Virginia. She would be 12 years old now. She has an age progressed photo to 11 years old. It says the other photos were taken before she went missing, and she may be in the company of her mom. Vitalia's height and weight are estimates for when she was last seen. So here's her age progress, which I could see it. I could see it in the eyes, and the little smile. I think it's, pretty accurate.
Mm-hmm.
Here are some additional photos. Oh, look how cute she is. Oh, she's adorable. I thought of that, Allie. She's so cute. So if you or anyone who knows information on her whereabouts, which I'm not sure why it's a California office, but please contact the LA County District Attorney's Office at 1-818-238-3000 or the Burbank Police Department in California at 1-818-238-3000, which that's both the same numbers. Okay. Why would it be California, though?
Burbank?
Yeah, no, well, like she is in West Virginia. Well, not West Virginia, Virginia Beach, Virginia. So I'm curious why they have the LA County.
Interesting.
There's Harlot. It's exactly what. Yeah, I knew you needed it, Harlot. That is what I did. I had nothing to do with jumping in a shower. It had nothing to do with wanting to get that done now, so I didn't have to do it later. I actually knew that you needed those 15 minutes, and that is why. You could ask Shay. I told her right before we hopped on, like, Harlot needed that time. So, just saying. Hi, Pity Mama. Tasting real pasta sauce for the first time was one of the first real betrayals from my mother. My childhood. Once you taste the real sauce, you can't ever go back. Okay. So, Shay.
Yes.
Shall we start? So Steve Goncalves did another interview. Hey, Shacto. He did. Oh, no, Daryl. Daryl, I will send it to you. I will send you those dots. Steve Goncalves did an interview that came out on Ashley Banfield News Nation last night. And apparently more information was within it. So would you guys prefer, Shay, to start with that interview and then the motions and whatever's filed on the docket, or would you prefer to start with the filings and then go to the interview?
The interview.
Okay. Okay, no hesitation. I buy a bushel of tomatoes and jar can. I love jarring them. I haven't in a long time, but I love jarring my. What does that mean? Well, I did jar the alavaca sauce at my mom's, so we don't have to redo it every time we go and visit, like, my daughter, and so, but as far as the mason jars, and there's such a process.
Are you melting over the tomatoes?
Yeah, sorry. Yeah, it's kind of a big deal. Just saying.
I will never talk to you about tomato sauce because I've seen the Shopping with Whoopi. I'm just going to keep my mouth shut because I cannot make homemade tomato sauce.
It's easy. It's easy peasy lemon squeezy.
Oh, you say that.
But once you do it, you'll never not. I promise you it's easy.
I'll trust you.
Daryl, thank you, Daryl. Welcome to our new members. Let me scroll down.
Thank you. You love me. You really love me.
And filling in every blank about
Ashley, you slow your roll. Thank you, Daryl. Congratulations. Don't let your typo stop you. I got paused. You typo away. All right. So this is since last night, and we have Idaho College survivors' text messages reveals new details of final hours. Now, again, we haven't caught up on all the motions yet, so there might be something within this interview that we haven't gotten to. And we're not aware of because, like I said, we've got a couple of things on the docket we have to go through. But I'm sure we'll manage. So let's take a listen. And I'm so excited. Okay, here we go.
Okay.
Gripping true crime case. But sometimes in this process, our hearts just get broken all over again each time we learn something new. And so it is with the University of Idaho murders. Since the case moved to Boise with a different judge, we've seen a blizzard of unsealed, unredacted court filings and a regular supply of details and disclosures, even some bombshells. And tonight, 2 absolutely stunning revelations about the surviving housemates texting and talking in the wee hours of November 13th, 2022. Also, a rare peek into some grand jury testimony, something we don't often get to see. We knew that Dylan Mortensen, a surviving roommate, had texted an Uber driver just after 2 o'clock in the morning. That's about 2 hours before the murders happened. But now we know that she and 3 of her roommates, Bethany, Kaylee, and Maddie, all of whom had just arrived home from a night out, had actually contemplated going out again. The court document reads, and I quote, "At approximately 2 a.m., they met up in Kaylee's bedroom and talked for a while before going to bed. The 5th roommate, Xana Kernodle, who was out with her boyfriend, Ethan Chapin, was not home yet. The roommates debated going out to the food truck for late night snack, prompting Dylan to send a text at 2:10 a.m. to an Uber driver she knew to see if he was driving. Ultimately, however, the girls decided to just go to bed."
So that explains the text.
Yeah, that makes a lot more sense now.
That makes a lot more sense.
Wow.
Ooh. And thank you so much, Jack. That's very kind of you. Hi, Harper's Nana. As long as I get the royal mashed potatoes, I'm in. Wow. Okay, so like, hey, are you driving? Pick us up, take us to the grub truck. Wow. Okay.
Man, that brings to mind a lot of what ifs, doesn't it? What if they'd gone back out?
Yeah, actually,
What
it
if
does.
they just decided, let's go, let's do it. It's 2 a.m. Let's go get more food. Might that have changed the course of history?
No, Ashley. I
Or-
wouldn't.
Of course, there is a good chance that they'd popped back out to that food trunk, that they still would have been home
Trunk.
before the knife-wielding intruder, allegedly Bryan Kohberger, broke in and killed Kaylee, Maddie, Xana, and Ethan. But we will never know. And that brings me to the second revelation. We knew about Dylan and Bethany's frantic text messaging between 4:22 a.m. and 4:26 a.m. when Dylan tells Bethany that nobody will answer their phones and that she's afraid because she saw someone in a ski mask. And we knew that Dylan then ran down to Bethany's room on the ground floor of the 3-level house. But the court documents now reveal a brand new fact that we never knew. And it is, honestly, it is something horrifying. Again, quoting Dylan. Dylan again tried calling Kaylee and Xana, but neither responded. Dylan then exited her room and began running towards Bethany's bedroom. On her way, she noticed Xana lying on the floor of her bedroom with her head towards the wall and her feet towards the door. Dylan thought Xana was drunk. Once Dylan arrived downstairs at Bethany's room,
The door wasn't shut?
they locked the door and both made additional unanswered calls to the other roommates.
Whoa.
She saw her. Okay.
The door wasn't shut. The door wasn't shut. Oh,
And Xana
wow.
I figured Xana, what you like, they could see. I didn't know she would see her going down, but I always said, how did she pass that hallway and get downstairs and not even look to the left,
Wow. Oh my God. Oh.
But then wait, if the door wasn't shut, Ashley, you put out your source a long time ago mentioning that door being shut, Miss Ma'am. That was Ashley Banfield.
Yes, and we've heard 2 different things. We've heard about something in the hallway, but we've also heard about a door being shut.
She was okay. So here we go with the Snapchat, right? She was contacting Ethan through Snapchat, which is, hey, it's not just random social media, contacting them through the Snapchat, calling through Snapchat. She again tried calling Kaylee and Xana, but neither responded. The grand jury transcript, Dylan then exited her room and began running towards Bethany's room. Ugh. On her way, she noticed Xana laying on the floor of her bedroom with her head towards the wall and her feet towards the door. Okay, so her feet would have been more front, like towards her, facing her. Dylan thought Xana was drunk.
Wow.
Right. That can't be true. And that came from Ashley Banfield Harlot. Hey, KV. Okay. All right. Let's just, because these are the documents we're going to be reading tonight. So let's just kind of watch it and then we'll figure it out.
Hours passed, and at 11:50 a.m. the next morning, 6 minutes before the 911 call that you have heard on this program, Dylan called her friends Emily Alant and Hunter Johnson because she was too afraid to go upstairs by herself. Yep. And the court filing reads, Emily and Hunter met Dylan and Bethany at the bottom floor of the house. Together, Dylan, Bethany, and Hunter started to walk up the stairs to the second floor. When they reached the second floor, Hunter went to the kitchen to grab a kitchen knife. Now, this next part is from Dylan's grand jury testimony. When Hunter came back out, Dylan said, quote, she saw Xana again for a split second, and this is Dylan talking, and just started bawling because she thought she had just I don't even know. I thought maybe she was still just drunk and all asleep on the floor. Bethany also saw Xana lying on the floor. Hunter told Dylan and Bethany to, quote, get out. Emily, who had started up the stairs, also turned around after Hunter instructed her not to come any further. They both went outside shortly afterwards, and Hunter exited the house and then told them to call 911.
I knew they saw her from the top of the stairs, and they didn't go any further, and he walked. And so instead of walking upstairs, I thought maybe he walked upstairs because you could hear in that 911 call, you could hear he's coming from a different direction, but it would make sense if he walked to the kitchen to get a knife.
Mm-hmm.
Okay.
I want to listen to the 911 call again now.
Yeah.
Different perspective. Okay.
Okay. They met Dylan and Bethany at the bottom of the house, the bottom floor of the house, okay, the front door. Together, Dylan, Bethany, Hunter started to walk up the stairs to the second floor. When they reached the second floor, right at the top of those stairs, Hunter went straight right to the kitchen to grab the knife. When he came out, Dylan saw Xana again, which, okay, she took another step and creeped down that hallway, took a look. And she saw her for a split second. And I just started bawling because I thought she had just I don't even know. I thought maybe she was still drunk and asleep on the floor. That was grand jury transcript. Bethany also saw Xana lying on the floor. And then Hunter told Dylan and Bethany, get out. And then Emily, who had started up the stairs at that point, also turned around, and you could hear you hear them all running down the stairs. They both went outside, and shortly after, Hunter exited the house and told them to call 911.
Wow.
Well, wait. No, if all of this came before calling 911. Huh?
Well, that may make sense when they're saying, do we have to go upstairs? Because they were asking if she was still breathing, remember? We had to read the documents, so I think we'll get more once we get into those. Because this is an excerpt. I understand, too.
Yeah.
I was thinking the same thing. I thought that coincided with the 911 call happening.
Right.
He was pale, white, and mentioned something about someone being unconscious. You can hear a lot of that. You can hear a lot of it on the 911 call. We just envisioned that the banging and the calling out, Xana, Ethan, was at the bedroom door, but it may not have been. It may have been down the hall and around the corner at the stairs.
That's what I always thought.
This is where I'm going to stop and bring in Steve Goncalves. Steve is Kaylee Goncalves' father. He's been a regular guest on the program. Steve, these were details that I found astounding They seemed to put into place more details of a very confusing picture of what happened that night. And I often stop and I think about you and the other parents, and whether you get a heads up that this stuff is coming, whether you have someone who sits down with you and goes through it and helps you to sort through it. How do you receive this kind of information?
We normally get an email beforehand. We work back and forth. I don't think either party really had an understanding of how to really construct something where you can share information but not too much information. But the communication's gotten a lot better. I've really grew to like these guys. I mean, I really care about that those people and all the work that they've done. So I think they've always tried to work towards communication, but I'm sure they're very busy, and it's not easy to always remember to keep us in the loop.
It was a surprise to me, Steve, to hear this detail that Bethany got a glimpse down the hall of what now appears to be Xana's open bedroom door, and Xana lying inside that bedroom door, and ran downstairs to Bethany's room. And then at one point, Bethany also saw that same image. But it's sort of just, it's flummoxing to think that they called friends, they called 911 before anybody sort of went to investigate what was happening in that bedroom with the door now open. We always assumed that it was closed and they couldn't get past it.
Yeah, that's definitely a puzzling part of it. But I always assume, you have somebody who's scared, girl, slightly, intoxicated. My own daughter, when my son was playing a prank on her, acting like he was being attacked, him and his mom, Kaylee ran upstairs and hid under the bed and called me at work. So when people are scared, they're young. They don't think the same way as a grown adult does. And I think they were just thinking that something bad had happened, but they didn't want to believe it. They weren't really prepared to mentally accept what was happening. And I totally understand that, because it's not something that we're used to in Idaho. It's not something that is common. It's not even, it's just unheard of. So I chalk it up to that. And I know that there's a lot of forensic, and there's a lot, these girls had their phones on. I already said way back in the day that you could tell when they went upstairs and downstairs. This is all laid out. Every step has been retraced. So it didn't make a difference in the bigger picture. And I've always said that there could be blessings for late calls as well too.
Yeah. It's also just so jarring to get the detail that the girls were all together up in your daughter's room, chatting about, let's all go out again, 2 o'clock in the morning, let's go back to the food truck. And I'm not sure if you heard how I laid it out at the top of the show, but all I can think of is the what ifs, if they had actually decided to go. And I'm wondering how you're processing that information.
I knew a little bit of the details about that. I don't even talk about some of it just because I don't want to hurt some of the people, that are involved in this. If, certain people would have picked up phones, all those type of things, those are what ifs.
The blessings from the late call was prior knowledge to the murders, according to Steve in the DTS interview. And there wasn't specific, right? But it indicated there was a search of some sort prior to 911 being called, which would also lead to possibly the return that he did the next morning around 9 a.m. Because no vandal alert, no news, no nothing that indicated cops had gone. And so he may have done a search. So that's what Steve's talking about.
But I think what it really goes to your audience is these girls were best friends. And even the last moments of my daughter and Maddie's, they were surrounded with friends, and they were in their beds. So just keep that in mind, because there's going to be probably some people are going to try to drag drag these surviving people through the mud, and up to their very last moments, they were hanging out with these, the people who passed away, planning on doing something fun. And my daughter came down there to hang out with one of those girls, and that's the reality of it. That's the truth of it, not some of the speculation that you're going to eventually hear about.
Yeah, and shame on those who have cast aspersions on these two surviving roommates who have been to hell and back. They're still there. They're not back. And how anyone could set upon them with ridiculous conspiracy theories is beyond the pale. There was something that you mentioned, I think a couple of days ago in an interview that sort of stood out to me. And that was that I think you had a chance to speak with the coroner and got a detail about one of the injuries that your daughter suffered at the hands of this killer. I think it was a punch to the face. Can you tell me what it is that you learned?
I don't go into all the details on it because I want the court to bring it out. I want them to do it. But yes, I feel 2.5 years. The defense has a strategy to have everybody forget. And I'm here to make sure they don't forget. So when I do have to let stuff out, it's because I don't want people to forget that we have a monster. And yes, one of the girls was a little more intoxicated. He was able to go after that Maddie May first, and my daughter woke up and he struck her multiple times and broke her nose. And yeah, and there's a little bit more details to that, but I leave that to them in case that's something pertinent for them to know and do.
Now it's broke her nose.
Whoa.
But I'm trying to think of his hand. So we have that thumbs up photo from the next day, Shay.
Yeah.
Even if he was wearing some type of gloves, I'm not an expert in that, obviously, but if you're punching like blunt force multiple times with your knuckles, would that not leave some type of marking?
I think it just depends on what type of gloves you're wearing.
Yeah, absolutely, definitely. Right, Harriet, that's a great point. Was it fist or was it the butt of the K-bar, potentially? That's a great point.
I mean, I always kind of held on to the theory that Truth Exposed about possibly him wearing some kind of butcher's type gloves or electrician gloves underneath, not like nylons, like something to help prevent cutting back on him,
Absolutely, and
So,
he was geared up head to toe.
mhm.
Oh,
Can we rewind that just like 30 seconds? Sorry, I'm just like, what? That hit me so hard.
yeah.
Oh my Lord. That was quick.
Stuff out, it's because I don't want people to forget that we have a monster. And yes, one of the girls was a little more intoxicated. He was able to go after that Maddie May first, and
Maddie
my daughter
first.
woke up and he struck her multiple times and broke her nose. And yeah, and there's a little bit more details to that, but I leave that to them in case that's something pertinent for them to know and to let them release it. But I'm not going to let anyone forget about what this monster did. And I'll leave it at that.
But they were able to give you that detail that that the killer killed Maddie first and then went after Kaylee second.
Correct.
I think there's a lot of forensics that we're going to learn in this trial. I hope you're going to be okay, you and Christy and the family, when it comes time for those testimony days. The last thing I wanted to ask you about, Steve, is that you've learned that Bryan Kohberger called out from work the day after these murders. What do you know about that, and how did you hear this?
There's a thing called the Bryan tally I've heard about. I've spoken because I was vocal, because I came out, some people reached out to me. This individual was an employee of WSU. And from there, I learned of some details. So, yeah, there was an investigation, an HR type investigation. And I don't know all the details about it, but I do know these girls felt very creeped out. They talked to people in power and they said document it, and they started documenting it, and that's how we know that one of the days, the day after he took that photo where he was acting like he's super confident, got away with murder. He doesn't look sick to me at all. You guys can look at, your audience can go look at it themselves. And I heard that's the only time he ever called in sick as well.
That's unbelievable detail. Steve, I always am very appreciative that you take the time to speak with us. I'm glad you keep your daughter's memory alive and the story alive as well. It's important that nobody forget what happened. Thank you again for this.
Yeah.
Steve Goncalves joining us from Idaho tonight.
Thank you for watching.
Wow.
Whoa. And thank you, Harper's Nana. The gloves that they wear when shucking oysters. Yeah, no, like as far as we know, he was covered head to toe, and we even got mention of a kill kit, which I believe at minimum would be a bag set beside that sliding door to place things in upon exit.
It's heartbreaking.
Yes, Chelsea. When Dylan stated a fireman suit, it immediately made me think of chest waders and gator waders.
Oh.
Okay.
The BK tally, apparently, like some of his I don't know, other like students he was in the PhD program with, they started this like Bryan tally, or even maybe the students as well, and they would like count up things that he did that were just odd and indifferent. It was kind of talked about like right whenever it was discovered that he was named as the person of interest and then indicted.
We have 3 new from today, but we need to go back a bit.
Yeah. So we didn't get to the Rylene Nowlin.
I know.
And I briefly read the motion eliminate regarding the family members in the courtroom, but it wasn't that much in there. It was a small one.
What date did we last leave off?
I think we kind of
18th? No, 20th.
Well, we started getting into the documents on the 18th, but there was one that kind of snuck in. If you scroll down just a little bit, that one on the 16th, that was one of the only other orders that I saw that was part of the motions eliminate that came from Judge Hippler. You see that one, the second to the bottom, that one right there. That's the only other motions eliminate one aside from the ones on the 18th that we started.
Okay. Well, I'm going to go in the order that I'm just most excited to see. Because now I need to see this. So this, because I now have questions. This is a 25-page document. Wow. Okay. So this is order on the state's motion eliminate regarding the text messages and the 911 call. So again, the introduction, Dylan and Bethany, the 2 surviving roommates. Dylan saw a masked intruder and began calling and texting the other roommates, including Bethany. So approximately 8 hours after Dylan saw the intruder, Bethany called 911 from her phone. Before the court is the state's motion to allow the text messages by Dylan and Bethany and testimony about their conversations with each other about what Dylan saw and the 911 call. The state argues these communications are either not hearsay or qualify under one or more exception to the hearsay rule. It also asks that a transcript of the 911 call be provided to the jury to view while listening to the audio. Kohberger challenges several of the communications and objects to the use of the transcript. Oral arguments were held, after which the court took the matters under advisement. The court finds that some of the hearsay statements on the 911 call do not qualify under the exceptions cited by the state and therefore must be redacted. However, the balance of the 911 call, as well as the texts and conversations noted herein, are likely admissible, provided that the requisite foundation is laid at trial. The transcript will be allowed as a demonstrative aid, again, assuming proper foundation is established. Okay. So the text and conversations. Okay. So we already have gone into this a million times. The present sense impression or excited utterance. So facts. After spending the evening out, roommates Dylan and Bethany, Kaylee and Maddie returned to their home at 1122 King Road in the early morning hours of November 13th, 2022. Let me plug this in. Okay. At approximately 2 a.m., they met up in Kaylee's bedroom and talked for a while before going to bed. The fifth roommate, Xana, who was out with her boyfriend Ethan, were not home yet. The roommates debated going out to a food truck for a late night snack, prompting Dylan to send a text at 2:10 a.m. to an Uber driver she knew to see if he was driving. Ultimately, however, the girls decided to just go to bed. At approximately 4 a.m., Dylan heard strange noises and crying coming from the bathroom. She opened her door at one point and saw a man dressed in black with a ski mask on walking by her bedroom door. She then placed calls and texts to her other roommates to see if they were awake. Only Bethany, who resided on the ground floor, answered. They spoke once for 24 seconds, during which she told Bethany that she thought she heard something. They spoke again a minute later for 41 seconds when Dylan told Bethany she saw a man in a ski mask leaving the house. They then exchanged the following text messages between 4:22 and 4:26. You want to be Bethany?
Yeah.
Dylan to Bethany, no one is answering. I'm really confused right now. Dylan to Kaylee. Kaylee. Dylan to Bethany. What's going on?
Bethany to Dylan. Yeah, dude. WTF. Xana was wearing all black.
Dylan to Bethany. I'm freaking out right now. No, it's like a ski mask almost.
Bethany to Dylan. Shut the F up, actually.
Dylan to Bethany. Like he had something over his forehead and a little on the mouth. Bethany, I'm not kidding. I am so freaked out.
Bethany to Dylan. So am I.
Dylan to Bethany. My phone is going to die. F.
Bethany to Dylan. Come to my room. Run. Down here.
Dylan to Bethany. I'm scared though.
Bethany to Dylan. Yeah, I know, but it's better than being alone.
So during the foregoing exchange, Dylan also attempted contacting Ethan through Snapchat. Grand jury transcript states she again tried calling Kaylee and Xana, but neither responded. Dylan then exited her room and began running towards Bethany's bedroom. On her way, she noticed Xana laying on the floor of her bedroom with her head towards the wall and her feet towards the door. Dylan thought Xana was drunk. Once Dylan arrived at Bethany's room, they locked the door and both made additional unanswered calls to the roommates. At 4:32 a.m., Dylan again texted Kaylee, "Please answer." So Bethany testified to her recollection of the content of those two phone calls before the grand jury. However, Dylan could not recall specifics about what was said. The typos and abbreviations are in the original messages, and Dylan testified before the grand jury that Instagram is a text messaging app that is used by young adults to communicate. So even the Instagram she was using, okay? So I know a lot of us were like, ooh, she's on Snapchat, Instagram, but we said back then she may have been attempting to make calls and messaging through that app. Thank you, Sin. That's so kind of you. Welcome, welcome. This is so intense, guys. Sorry, like this is so very intense. Hi, Miriam. Okay. So it says 4:32 a.m. Dylan again texted Kaylee, "Please answer," with no response. Between approximately 5 and 6:30 a.m., Dylan engaged in activity on her phone, primarily creating, editing, and deleting images and videos. Her phone activity then ceased until 8:05 a.m., when Dylan accessed Instagram for a few minutes. At 10 a.m., Dylan again accessed Instagram and communicated over Snapchat. At 10:23, she texted Madison asking, "Are you up?" She receives no response. Dylan continued to access Instagram and Snapchat until 11:29 a.m. when she texted Kaylee, "Are you up?" Again, there was no response, which Dylan thought was strange because Kaylee and Maddie were early wakers from the grand jury transcript. Dylan continued accessing various social media sites, including checking Ethan and Xana's Snap Map locations.
Oh.
At approximately 11:40, Dylan's father texted her about scheduling a time for a chat, to which Dylan responded. She also received 2 texts from a person named Jenna stating, "Bro, and do you guys need me to come get you?" At approximately 11:50 a.m., Dylan called her friend Emily and asked her to come over and check the house because she was scared. Emily and her boyfriend Hunter came over. They met Dylan and Bethany at the bottom floor of the house. Together, Dylan, Bethany, and Hunter started to walk up the stairs to the second floor. When they reached the second floor, Hunter went to the kitchen to grab a knife. When he came back out, Dylan, quote, "saw Xana again for a split second. And I just started bawling because I thought she had just I don't even know. I thought maybe she was still drunk and all asleep on the floor," from the grand jury transcript. Bethany also saw Xana lying on the floor. Hunter told Dylan and Bethany to, quote, "get out." Emily, who had started up the stairs, also turned around after Hunter instructed her not to come any further. They both went outside. Shortly afterwards, Hunter exited the house and told them to call 911. He was pale, white, and mentioned something about someone being unconscious. At 11:56 a.m., Bethany called 911 from her cell phone and spoke to Carolina Calvin, the 911 dispatcher. The call lasted 4 minutes and 11 seconds. During the call, the phone was passed around to different individuals, including Bethany, Dylan, Hunter, and an unidentified female speaker. Heavy breathing, and crying can be heard throughout the call. Bethany spoke first, stated, quote, "something is happening. Something's happened in our house and we don't know what." Bethany attempted to provide the address of the house to dispatch but could not continue. At that point, an unidentified female speaker took the phone and provided the address and Bethany's phone number. The following exchange ensued. What do you want, B?
I'll be the 911 operator.
Okay.
Okay, and tell me exactly what's going on.
One of the roommates who's passed out, and she was drunk last night, and she's not waking up.
Okay.
Oh, and they saw a man in their house last night. Yeah.
And are you with the patient?
Hi, this is Dylan.
Okay, I need someone to keep the phone. Stop passing it around.
Can I just tell you what happened pretty much?
What is going on currently? Is someone passed out right now?
I don't really know, but pretty much at 4 a.m.
Okay, I need to know what's going on right now. If someone is passed out, can you find that out?
Yeah, I'll come on, B. We've got to go check, but we have to. Is she passed out? She's passed out. What's wrong? She's not waking up. And Hunter says, "Xana, you're much kinder than the actual 911 dispatcher, just saying." So Dylan then informed dispatch that Xana was 20 years old. At that point, Hunter took the phone. Dispatch asked him if she was breathing, to which Hunter answered no. Law enforcement arrived at that point, and after confirming with Dylan that the responding officer had a defibrillator, dispatch ended the call. Later, at approximately 1:04 p.m. that day, Dylan received a vandal alert regarding the homicide. Wow.
You want me to start the analysis?
Yeah, but what are your thoughts so far?
Don't even know. I'm just, I'm shocked. I'm still processing, to be honest.
I know.
That
The
they
one.
saw her.
Yeah, go ahead.
I guess, I guess I'm just struggling with like this. She heard somebody say, "I'm here to help you," and then she sees Xana lying on the floor. Then she sees somebody walk out, but then she thinks Xana's drunk, laying on the floor. Like, I, I'm just really confused, and I'm trying really hard not to go there.
Right. And I understand she wasn't in a good state of mind. She was intoxicated. She wasn't understanding what was going on. But I'm trying to keep in mind how Steve mentioned, oh, yeah, no, we were dealing with minors here. And they did have the cops frequent, and it potentially could mess up graduation. And there was a fear of wait till we speak to someone who's 21 because they could get in trouble. But you would think at that point, with all of these factors, it would be concern enough to there's a serious issue here. But I'm more hung up on, as far as we understood, that door was closed, and I'm even more confused right now because didn't we read the documents that stated? No, the document stated at the time
And
they
said the
arrived.
doors were open.
Yes, at the time that they arrived, the doors were open.
Mm-hmm.
But I thought Steve had said earlier on that he was told by Hunter the story of having to push open and look in. Which, guess what? I guess that could still technically be somewhat true if the door was somewhat open and you could see Xana with her body, which, okay, I speculated that before. Her body was somewhat visible with the feet towards her, like, but it would be open enough to where I wouldn't anticipate having to push it open to see Ethan. So I'm a little confused. And when Ashley mentioned that, it didn't seem like Steve had any clarification on that, because he said, yeah, that's a little bit, what did he say? Yeah, that's a little bit confusing. I'm not sure what he said, but something like that.
Yeah.
Thank you, Linda. This is so heartbreaking. It is. It absolutely is. So I have some questions about that so far. But all right. So you could read the analysis.
Yeah. No, I feel you. I have the same thing. And I understand that, like, we obviously the public's not going to see a lot of the, um, probably the evidence and the photos of the crime scene.
No.
But I am curious if they say they do that 3D model or the demonstrative, right? Exhibit, or is there any way that they could at least like pinpoint, like on a, I don't know, a floor plan of where they're found for those that aren't going to be able to see that, to have a better understanding.
Because if they were gonna put like, let's say, like, think about like Gray Hughes's walkthrough, right? And you could see like the
Mhm.
outline of the body or something. They can't do that because Anne would argue, excuse me, like, I need to have it completely technical of if this was exactly where the body was laying, and nope, it's supposed to just serve as, to help point to understand the layout of the house and nothing more. So I don't anticipate. Now, will we get people who are at trial maybe able to create based on what they see? Yeah, but not anything direct from the court or anything like that.
Yeah. Yeah, good point. All right, the analysis. The state seeks to admit Dylan and Bethany's phone records from November 13th, 2022, including call records and text messages, as well as elicit testimony by Dylan and Bethany regarding their communications with each other on November 13th that they testified to before the grand jury. The state also seeks to admit the 911 call and the official transcript thereof. The state argues these records and communication are not hearsay, or they are accepted from hearsay as excited utterances or present sense impressions. Kohberger objects, arguing that apart from Hunter's statement to 911 that Xana was not breathing, the exceptions do not apply to the hearsay statements. The court finds the bulk of the statements are likely admissible, with 3 exceptions of statements made during the 911 call. Hearsay is an out-of-court statement admitted to prove the truth of matter asserted. To be hearsay, the statement must be intended as an assertion of fact and offered by the proponent for purposes of proving the truth of the assertion. If a statement is hearsay to be admitted, it must fall under an exception. Okay, so these are going through the exceptions.
It's all that.
Okay, and
Yeah, you can
considering
just read
whether
It's all the same. You can just read this.
Got it. Text messages. Text messages and verbal conversations between Dylan and Bethany are likely admissible. As an initial matter, the court finds that Dylan and Bethany's acts of making phone calls, sending or receiving text messages, and other phone activities such as accessing social media are not hearsay. Hearsay only captures an oral assertion, written assertion, or nonverbal conduct intended as an assertion. Thus, this order will focus on the content of those calls and texts to the extent available. As to the content of Dylan and Bethany's text messages about what Dylan saw, the court finds they are either not hearsay because they are not offered for the truth of the matter asserted, or not assertions, or if hearsay, they likely qualify as a present sense impression and or excited utterance as set forth in Exhibit A here too. Their verbal discussions are potentially admissible for these same reasons. The state must establish the foundational requirements for such proffered statements at the time of trial. 1. DM texts Uber driver at 2:10 to inquire if he is driving. The state seeks to introduce this text to establish a timeline, specifically to establish Dylan was awake and texting at 2:10 a.m. Kohberger does not directly challenge the text because it is not offered for the truth of matter. The court finds it is not hearsay. 2. Text messages between 4:22 and 4:26 a.m. The state argues that the 4-minute series of text messages between Dylan and Bethany, with one from Dylan to Kaylee, are admissible as either present sense impressions or excited utterances. Kohberger suggests neither exception applies because there's no evidence they were sufficiently startled by the events. He points out that Dylan claimed only to be, quote, confused, unquote. And despite stating she was scared, she ran to Bethany's room instead of leaving the house or otherwise calling other friends and family for help. The court agrees with the state for those texts qualifying as assertions. First, the present sense impression exception does not require a startling event and simply requires that the speaker describe or explain a condition while personally perceiving it or immediately thereafter. 1. Most of Dylan's texts to Bethany satisfy this exception. She texts that no one is answering, which describes the results of her calls to the other roommates just moments before. She also states what she is immediately feeling: confused, freaked out, and scared over what she just saw and heard and the fact that none of her roommates are answering. She further describes the intruder she saw, i.e., wearing a ski mask or something over his forehead and mouth. She also relays that her phone is going to die. Thus, these statements are all likely admissible as present sense impressions. In addition, the events are sufficiently startling to both Dylan and Bethany for purposes of the excited utterance exception. Dylan and Bethany are young female college students. Let me see. Is there anything in there that we need to go over? No.
I like that it's like, it explains the typo she's writing. She's scared. Considering that the A is right next to the caps lock key and the E is right next to the W key, it's evident that she was likely quickly texting and accidentally mistyped scared.
Dylan and Bethany are young female college students and the self-described scaredy cats of the house. That is according to a grand jury transcript. They were awoken from sleep. So that's interesting. They're called the scaredy cats.
Yeah.
They were awoken
Justin.
from sleep after a night of drinking, with Dylan reporting that she heard noises and saw a masked intruder in their home. None of the other roommates were responding to their calls and texts, further indicating something was amiss. It would be potentially terrifying for anyone, including these young women. To argue that they would have run out of the house or called someone else for help had they have been really startled, um, unemphatically ignores these circumstances and the trauma and confusion they were evidently experiencing, which likely offset logical thought. Indeed, the girls' fear and confusion is evident in their words, with both questioning what was going on. Dylan stating she's freaked out, scared, and confused, and Bethany attempting to get them together quickly for safety. They were clearly under stress and attempting to make sense of a frightening situation. Additionally, the time period that elapsed between what Dylan saw and her communications with Bethany about this same was a matter of minutes. The text message exchange lasted approximately 4 minutes, with the messages occurring in rapid succession. This timeline left no time for reflection of fabrication, um, which is under Idaho law, and they seek to protect against. Consequently, the court concludes that the assertive text messages within this 4 minute period are likely admissible as present sense impressions and are excited utterances, assuming the requisite foundation is provided at the time of trial. 3. Dylan texts to victims. At 4:32 a.m., Dylan texts Kaylee, "Please answer." The state argues this text is admissible. Kohberger does not directly address the text. However, the court finds it more of a command or request than an assertion of fact. It's not fact capable of being proved true or false. That thus it is not barred by the Idaho rules. At 10:23, Dylan texts Madison asking, "Are you up?" And approximately an hour later, Dylan texted Kaylee, "Are you up?" The state argues that these texts are not hearsay, that they will not be introduced for the truth to matter. Alternatively, the state contends that they are present sense impressions. Again, this is consistency with Dylan's text from the prior night. Kohberger disputes that the exception applies, pointing out that Dylan had been awake and accessing social media before she sent the text. Again, the court does not find these texts to be assertions, they're inquiries, not declarative statements. Even if they were assertions, however, if the state intends to omit the statements to establish a timeline of events, they are not hearsay because they're not offered to establish truth. They're not barred. And I was going to see what was under the subscript, if it was anything worth. Um, okay. 5. Dylan's calls and texts to and from others. The state contends that the text between Dylan and her dad, the text from JM, and the vandal alert are not hearsay because they will be offered simply to show a timeline for the morning and early afternoon. In addition, the state notes that the phone call from Dylan to Emily is not a statement and therefore not hearsay. The court agrees and will allow the evidence for a purpose of timeline with the requisite foundation laid. B. Verbal communications between between Bethany and Dylan. The state next contends that it intends to ask Dylan and Bethany at trial about statements they made to each other on November 13th. It argues the testimony will likely replicate that provided by these witnesses at the grand jury proceeding. The state contends that they are admissible. Again, Kohberger does not directly address this argument. To the extent Dylan and Bethany seek to testify about the content of the calls, text, and conversations about what they perceived during the 4:30 timeframe, they could be potentially admissible under the exceptions cited by the state. However, the state must establish the foundational requirements for such proffered statements. The grand jury testimony does not appear to include any conversations between them after the 4:19 a.m. to 4:37 a.m. timeframe, and the state has not pointed any out. Thus, to the extent they testified to oral conversations they had after they woke up the next morning, the court will reserve ruling and consider any hearsay objections at that time. Whew. And then we got the 911 call. The state contends that the entirety of the 911 call, or sorry, do you want to do this one? I just started going. I'll roll with it. The 911 call. The state contends that the entirety of the 911 call should be admitted because the statements therein are either non-hearsay, i.e. not admitted for the truth of matter asserted, or they are accepted from the hearsay rule. I'm just gonna kind of keep going. The initial statements. The 911 call begins with Bethany telling dispatch something is happening, something's happened in our house, and we don't know what. The statement falls squarely within the present sense impression, the exception given that Bethany was experiencing concern that something was wrong with their roommates, and Hunter had just instructed her to call 911 after walking through the house. Thereafter, Bethany attempts to provide dispatch with the address of the house before an unidentified female speaker takes the phone and provides the address and Bethany's phone number. This exchange is not offered for the truth of the matter asserted and therefore not barred by hearsay. 2. Female. Um, one of our roommates is passed out and she was drunk last night and she's not waking up. The state argues this statement is present sense impression. However, Kohberger points out the roommate at issue in this statement is Xana. The only individuals who experienced or saw Xana unresponsive were Dylan, Bethany, and Hunter. Thus, Kohberger contends the exception does not apply because the female speaker never saw Xana unresponsive and thus lacks firsthand knowledge of the information contained in this statement. The inquiry here turns on whether the event female speaker is describing or explaining is that Xana is unresponsive, as Kohberger contends, or whether it was more generally the scene unfolding at the house, i.e., that her friends saw Xana unresponsive. The female speaker did not personally perceive the former, but she did personally perceive the latter. When the words themselves are considered, it is clear the event being described is that Xana is unresponsive, not that the speaker's friends saw Xana unresponsive. In other words, she is relaying to 911 what her friends observed and relayed to her. Her statement is therefore outside her present sense impression, and thus the exception. Um, do, do, do. Okay, the statement is not admissible under that exception, basically. 3, the female, oh, and they saw some man in their house last night. Yeah. State argues this is, okay, again, present sense impression. I'm going to kind of keep going through this because it's kind of repetitive. Additionally, there's no contemporaneity since she is describing an event that occurred hours earlier. The excited utterance does not apply here either. Idaho Supreme Court considered whether this excited utterance is applied to a 911 call made. Okay, I'm gonna keep rolling. Sorry, these are a little bit repetitive. Here, likewise, the audio of the 911 call does not indicate that the speaker's normal reflective thought process were rendering inoperative. Her voice sounds calm relative to Bethany's and Dylan's, although a slight nervousness can be detected in her voice. She is not audibly crying or breathing heavily. In fact, the speaker took over speaking to dispatch because she was more composed than Bethany, who initiated the call. Further, the speaker did not personally see Xana unresponsive, nor did she see the man allegedly in the house. She is simply repeating what others told her. So the statement does not provide insight into her own thought process. So this, consequently, the statement must be redacted. Dylan's attempts to explain events. After the speaker cedes the phone to Dylan, Dylan identifies herself and asks if she can tell dispatch what happened. Dispatch responds by asking what is going on and if someone has passed out. This exchange will not be offered for the truth of the matter asserted and therefore is not hearsay. However, Dylan then states, I don't really know, but pretty much at 4 a.m., the state argues this statement is present sense impression. Dylan is trying to explain to the dispatcher what she saw while under the current excitement of realizing that her roommate is not waking up and something could be wrong in the house. Kohberger disagrees, noting that the event Dylan begins to describe would occurred 8 hours prior. He further argues it is not an excited utterance because she and Bethany had several hours to reflect on what she had seen and experienced at 4 a.m. Kohberger is correct that the statement does not qualify as present sense impression. While Dylan personally perceived the event she is beginning to describe, the contemporaneity aspect is missing. She's attempting to narrate an event she saw 8 hours earlier. So the excited utterance exception doesn't apply either. While Dylan is no doubt under the stress of excitement caused by realizing Xana is unresponsive, her reflexive thought process appears intact. She is starting to draw connections between Xana being unresponsive and what she saw and heard 8 hours prior, something she has had time to reflect upon. She does not launch spontaneously into what she saw at 4 a.m. Rather, she asked the dispatcher if she can explain what she saw. Based on this exchange, it's clear that her powers of reflection are quite active, thus obviating the purpose behind the exception. This statement is not admissible and must be redacted. 5. Statements regarding Xana. Dispatch then instructs Dylan to find out if someone has passed out. Dylan appears to make statements to bystanders that they have to go check if Xana is passed out. This is not offered by the state of the truth of the matter, therefore not hearsay. Dylan then states that Xana is not waking up. Hunter is heard stating Xana in the background. There are squarely present sense impressions because they are describing what the speakers are seeing. Dylan then responds to dispatch's inquiry about Xana's age, again, not offered for the truth of the matter, before Hunter takes the phone and confirms that Xana is not breathing. This is a present sense impression and will fall under Idaho law.
Makes sense. Okay, 6, we have the statements after law enforcement arrived. So around the time Hunter confirmed to dispatch that Xana was not breathing, law enforcement had arrived on scene. Hunter can be heard telling Dylan, quote, "I need you to talk to them. I can't talk to them. I need you to talk to them." The court finds this admissible as either a present sense impression or excited utterance. Hunter had just discovered Xana's body moments before. He is operating under the stress of discovery and attempting to answer dispatch's questions. His statements describe his inability to speak to law enforcement at that moment and therefore are admissible. At that point, Dylan took the phone again and dispatch instructed her to get a defibrillator if one was available. Dylan asked dispatch to repeat the question and stated, quote, "There's a police here right now." After dispatch repeated the question, Dylan indicated they did not have a defibrillator and asking the responding officer if he did. The officer responded affirmatively, after which dispatch indicated she was going to let the officer take over and ended the call. So the state seeks to admit the statements for their truth. They qualify as present sense impressions, as Dylan is explaining the events as they're happening. They're also likely admissible insofar as they regard to the defibrillator. Finally, many of the statements are not assertions and thus not hearsay. So the crying, breathing, heaving is non-hearsay. Apart from the statements, the state also moves for admission of the audible crying, breathing, and heaving made by the 911 callers. Kohberger does not address the argument, and the court finds it's well placed. While assertive conduct can qualify as hearsay, non-assertive conduct does not. It refers to case law. So there is no indication in the 911 call that the speakers are intending to make an assertion through their crying and heavy breathing. It is clearly an involuntary emotional response to the circumstances. Further, it is relevant to show the stress and emotional impact the girls are under, which puts the call into context. Thus, it's admissible. A transcript of the 911 call will be allowed as a demonstrative evidence. The final issue is whether to allow the jury to view the official transcript of the 911 call while listening to the call. Kohberger contends it would be cumulative and asks that either the call or the transcript be allowed, but not both. The court views this issue as essentially a request for use of the transcript as a demonstrative aid. A demonstrative exhibit is relevant if it, quote, supplements the testimony of witnesses or assists the jury in obtaining a better understanding of facts in the issue. It quotes case law. So when used in this way, courts will typically instruct the jury that the transcript is not evidence independent of the audio recording, and if the jury determines that the transcript is incorrect, it should disregard it to that extent and rely on its own interpretation of the audio recording. In addition, the transcript must be authenticated by showing that it fully and accurately complies with the audio recording. Against this background, the court will permit a transcript of the 911 call to be used as a demonstrative aid, assuming the proper foundation for the 911 call is established and that the transcript is properly authenticated. To this end, the state is responsible for proposing an appropriate jury instruction. The transcript will not be admitted as substantive evidence and will not be available to the jury except when the 911 call is being played, including during deliberations. Because it is not going to be used as evidence, the court does not find that the transcript is cumulative to the 911 audio or otherwise prejudicial to Kohberger. Okay.
Oh, that's not as long as we thought.
So this breaks down all of the texts and calls.
Okay. Yeah, we've seen those.
This is just going through the 911 call and then explaining each line, what it's being admitted under. Okay. Do we know which one mentions it would be defense? Good night, Justin. It would be defense trying to admit their expert regarding the potential of 2 weapons.
If I'm correct, I think that's the order. Hold on 1 second.
Hold on, guys.
So we had the Riley, that's the touch contact.
Oh, I think I found it. Yep, I found it. Okay.
Which one was it?
The order eliminate vague and undisclosed.
Okay. Okay, I didn't scroll up enough.
So this is the defendant's motion. I don't think, Ms. Nika, it's... Oh, I hope that your recovery is going well, Misty. I don't think it's out of the ordinary to for them to try to get things thrown out. But yeah, it seems like she's trying to get everything thrown out. I'm not used to seeing every single thing thrown out like that. But I mean, correct me if I'm wrong, Shay. Have you seen, it's not that often I see that.
Not to this degree. I just think there's a lot of bad facts.
Yeah.
That are against the defendant right now. That's just my opinion on the matter, based on other cases I followed.
So this is the order regarding defense's motion for the vague and undisclosed expert testimony. So I don't need to read the whole introduction because it just explains, like, we've gone through those motions so many times, but it's going to go each bit by bit. So we have the rule requires the state to provide, upon written request of the defendant, a written summary or report of any testimony, right, that these experts intend to introduce at trial that qualifies as expert witness testimony. So the disclosure must include a summary of the witness's opinions, the facts, the data for those opinions, and the witness's qualification. When a party fails to comply with discovery, the trial court may impose sanctions, including, in appropriate circumstances, the exclusion of that witness. So we have Jenny Ayers. So Jenny is a forensic scientist with the ISP who works in evidence collecting and crime scene processing. She is disclosed to testify in the state's case in chief about crime scene processing generally, including collecting DNA, bloodstains, latent fingerprints, hair and fibers, and shoe impressions. She will explain what DNA is, that it may present in biological material or left on an item when handled, and that it is collected for preservation and sent elsewhere for testing. She's also going to testify to her work in this case detailed in Lab Report 25 and supporting field notes. That report discusses ISP's processing of Kohberger's Pullman apartment and WSU office, which included photographing and collecting evidence. Miss Ayers was specifically involved in capturing images of the apartment and office and performing presumptive tests for the presence of blood at various points in the apartment. Her rebuttal testimony concerns ISP's crime scene investigation procedures generally and the ISP's forensic team processing at the crime scene of 1122 King Road, including identifying areas that contained probative evidence. In addition, the lab report and field notes for the team's work are referenced by Bates within the disclosure. So Kohberger argues Miss Ayers' case-in-chief disclosures do not provide any opinions she has about crime scene processing or about the DNA at issue in this case. Thus, Kohberger asked the court to limit her testimony to her qualifying background and her work in Lab Report 25. As to her rebuttal disclosure, Kohberger argues again that it fails to provide any opinion about crime scene investigation procedures, and it does not clearly state what she did in processing the 1122 King Road and what her opinion in regarding that work. Kohberger challenges misapprehend the type of expert Miss Ayers is. Much like law enforcement, Miss Ayers is a hybrid fact expert witness as opposed to a traditional expert. She will be educating the jury on crime scene investigation procedures to provide foundation for her testimony regarding the work she and her team performed in this case, as outlined in Lab Reports 25 and 11 and the accompanying field notes. This testimony is factual in nature, despite the fact that it requires special knowledge, skill, experience, and training. Consequently, the absence of opinions in her disclosure does not limit her ability to testify to these matters. In addition, Ms. Ayers' rebuttal disclosure is replete with explanations about why and how the crime scene investigation was carried out at 1122 King Road, and her testimony will be allowed as disclosed. So we could just bounce back and forth. You could take Special Agent Nicholas Bounds.
All right. FBI Special Agent Balance was primarily involved in the analysis of cell phone records in the investigation. He is disclosed to testify in the state's case in chief about his analysis of AT&T cell phone records for defendant Madison Mogen and Xana Kernodle, as well as his own drive testing measurements to determine the use and general location of their cell phones between June 2022 and November 2022. Accompanying his initial disclosure in his 30-page cast report, which discusses and maps the data he reviewed and the methodology employed. Initial disclosure, Exhibit S2A, his supplemental disclosure goes through each page of the cast report to discuss its significance. He will also discuss topics pertaining to how cellular technology works, particularly how cell towers operate and how cell phones connect to the towers, how cell phone usage data is reflected in call detail records, and how those records provided by AT&T for the target cell phones in this case were used to create cell site maps showing their general location before and after the homicide and their direction of travel. So, okay. I've seen if there's anything in the subscripts. I guess not. Okay. In challenging Agent Balance's case in chief disclosures, Kohberger provides the affidavit of his cell phone data expert, Cy Ray. Mr. Ray complains, that's putting it nicely. Mr. Ray complains that he is unable to identify Agent Balance's methodology, which was described in the cast report. Mr. Ray states that the cast report omits data and or fails to mention how certain AT&T data was utilized in his
Mm-hmm.
analysis. In
Sure
parentheses,
did. Sorry.
yeah, no, you're fine. Namely, handoff data and drive test mapping, and why some data was ignored. He
Mm-hmm.
assert he
Sorry.
asserts you're okay. He asserts his omitted data and methodology is exculpatory, and without it, he cannot fairly analyze Agent Balance's work. According to the state, its disclosure sufficiently identify Agent Balance's opinions and the facts and the data he relied upon, and Kohberger's concerns are fodder for cross examination. In fact, in Agent Balance's rebuttal disclosure, the state marches through each concern outlined by Mr. Ray,
Uh-huh.
offering, offering additional explanation about what Agent Balance considered, including the handoff data and why. Kohberger, however, asserts the attempted clarification in the rebuttal disclosure is insufficient, arguing there is no disclosure as to why he has omitted 95% of the relevant coverage maps for his drive testing. No analysis or mapping of the handoff data and no documentation provided of the cast report's peer review process. However, the fact remains that Kohberger has all the facts and data that Agent Balance relied upon to form his opinions, which are expressed within his cast report. Initial disclosure, page 4. The data supporting SA Balance's opinions is located in the files of the cell phone records provided by AT&T and the drive testing files, which were provided to defense through discovery. And supplemental discovery, page 2, identifying disclosed information relied upon by Agent Balance by description, AV number, and date disclosed. While his methodology might not be set forth, here, I want to read those subscripts real quick.
I would just finish and then read the subscripts because there's just a little chunk.
Okay, set forth with as much specificity specificity as Mr. Ray would like, Rule 16 does not require that detailed methodology be provided. It requires merely opinions, facts, and data for those opinions and the witness's qualifications. ICR 16B7, to the extent Kohberger believes Agent Balance omitted important data or is relying on insufficient data for his opinions. This is fodder for cross-examination, not exclusion.
Yep.
Moreover, if an opinion is not reasonably set forth within the disclosure, it will not be allowed. And it says, Mr. Ray notes that Agent Balance failed to include an analysis of handoff data for Kohberger's cell phone between the hours of 2:30 and 3 a.m. on November 13, 2022, that he did not include the mapping he relied upon to establish Kohberger was near the crime scene on several occasions before the crime, and he failed to disclose how his drive testing works to a sufficient degree. Also, there is no requirement under Idaho law that the state provides peer review documentation of an expert's report. Likewise, the rule does not require an expert to identify the data they did not rely upon or why they did not rely upon that data. And lastly, a draft of the cast report was disclosed to the defense in the early stages of this case. It was subsequently peer reviewed, and the final cast report was issued and disclosed in July of 2024.
Okay.
Yikes.
Mm-hmm. Heather and Jared Barnhart. The Barnharts are digital specialists with Cellbrite who were retained by law enforcement to analyze Kohberger's cell phone and PC to determine, quote, user behavior and actions. They are disclosed to opine that the gaps in data on the two devices were, quote, abnormal. Attached to the disclosures is a report jointly authored by the Barnharts detailing their analysis and findings. Their CVs were provided as well. Kohberger argues that the disclosures indicate they will testify to, quote, habit evidence. Oh, yes, they will. which he complains is not explained and is not accompanied by any opinions. Kohberger's challenge is confusing. Nowhere do the disclosures or the report indicate the Barnharts will testify about habit evidence. Rather, the disclosures state they will testify to their findings pertaining to Kohberger's activities on his PC and cell phone for a period of time before and after the homicides, and why gaps in data over that time period are abnormal. The Barnhart's opinions regarding these topics are fully set forth in their joint report. For example, hold on. Let me read these before I go to explain. So, Kohberger complained at the hearing that Agent Balance analyzed handoff data for the 7 minutes prior to the phone powering off at 2:54 a.m., but did not provide an opinion about what his analysis showed. Thus, Kohberger wants to exclude any opinion as to what his analysis of those 7 minutes showed. However, as pointed out in Balance's rebuttal disclosure, the CAST report sets forth the data Agent Balance relied upon to opine that Kohberger's phone used a certain tower and sector at 2:47 a.m. southeast of his apartment and ceased communication with the network at 2:54. He also explains that the location of a device is best estimated by the initial cell site versus the handoff cell site. He will be allowed to testify to these opinions. If Kohberger believes Balance strays beyond these opinions, he can object and the court will take the matter up then. So the state submitted the following disclosures for the Barnharts. They intend to rebuke the expert testimony of Carol Pendon, Kevin Pendon, and Josiah Roloff, but need additional information prior to offering rebuttal opinions. Kohberger is not challenging these. Specifically, their report explains that the gaps in data may be consistent with, quote, cleaning up or using anti-forensic methods to clear evidence. So, for example, they observed gaps in Kohberger's school PC that, quote, may be consistent with cleaning up or using anti-forensic methods to clear evidence. Among the gaps found were in the PC's event logs and the system resource usage monitoring between November 11th, 2022 and November 16th, 2022, which Barnhart's opined was abnormal given that school was in session. Likewise, they located gaps in the PC's Chrome history during dates where downloads occurred on the system, indicating the user was private browsing or clearing browsing history. Together, the Barnhart's disclosures and joint report set forth all that is required by ICR 16b7, and there is no basis to exclude or limit their testimony. I just like saying the name Barnhart's. It's like a fun name to say. The Barnharts.
I think we need to get you that little clip to play the "Don't be suspicious."
Don't be suspicious. Don't be suspicious.
What were you clearing, Mr. Kohberger?
What were you clearing, Kohberger? And they're like, well, you can't testify about the habits. No, but I could sure as fuck take this time period and tell you what is abnormal versus what is normal usage. The same way all of like our phones, guys, is it abnormal for you to shut your phone off every night when you go to sleep? Like literally turn it off? Okay, right? So you could know, hey, normally you don't. You turn it on silent mode, you may turn it on airplane mode, DND, but you don't power it down. So if you powered it down one night, that's going to be abnormal.
It's wild, man. Oh, I can't wait.
Okay.
Michael Douglas. Mr. Douglas is a forensic accountant for the FBI and is disclosed to testify to financial transaction data for Kohberger, the 4 victims, and the 2 other roommates. His initial disclosure identifies by category and date range the financial transaction data he intends to testify to and appends Mr. Douglas's report of specific transactions found within these individuals' financial data. His supplemental disclosure identifies more specifically the financial data associated with Kohberger that he intends to discuss and also identifies video evidence obtained showing Kohberger's ATM withdrawals. Kohberger contends that Mr. Douglas should not be able to offer any opinions because none are expressed in his disclosures. Specifically, Kohberger notes that Mr. Douglas's supplemental disclosure indicates he will testify to an analysis of Kohberger's spending habits. Kohberger takes issue with this, arguing there is no spending habit opinion disclosed. However, Mr. Douglas' disclosure makes clear that he is intended as a fact witness and is only being disclosed as an expert in the event the court determines his testimony was based on specialized knowledge under Idaho law. Moreover, although the supplemental disclosure appears to indicate he will offer an opinion as to Kohberger's spending habits, and his testimony will be limited to factual changes in how Kohberger spent money. For example, the disclosure notes Kohberger only conducted ATM withdrawals on.
Sorry, I read ahead. Sorry.
Whoa. Okay, so he only conducted ATM withdrawals on and after the date of the homicide and ceased using his debit card after November 10th, 2022. Whereas prior to November 10th, he had regularly used his debit card. There is no indication he will attempt to opine about the reasons for the spending changes, just that they occurred. Thus, there is no basis for excluding or limiting Mr. Douglas's testimony based upon disclosure concerns. Wow. What's up with them ATM withdrawals? What you doing? Interesting. Or does he not think that they have cameras there? Like, I don't get it.
I don't know. Okay. Thank you, Daryl. Welcome.
Yippee-ki-yay, motherfucker. Thank you very much.
Yes, Harlan. Sorry. Thank you so much, Daryl. Welcome. But yes.
But they, like, they always say, like, to get away with the perfect crime, like, don't change your daily habits. Like,
yeah,
this.
dumb, like not going to work and calling in sick for the first time ever. Or how about ceasing using your fucking debit card and all of a sudden using cash withdrawals? Or how about disconnecting from the local network? I don't know, dude. Taking a thumbs up pic all of a sudden the day like, what the Elmer Fudd are you up to, dude?
Allegedly the only day you call into work.
Uh-huh. Okay, so the next one after Shane Cox is the one. Okay. So Shane Cox, Mr. Cox is a litigation.
Do you want me to read this one so you can do Darren's?
Okay.
Because I know you get into that. I can do Shane, so you can do Darren.
You mean I get excited?
Yes, you can do Shane. Or sorry, you can do Darren and get excited. Okay, Shane Cox. Mr. Cox is the litigation and regulatory manager for Amazon.com. His initial disclosure states Mr. Cox will testify to the content of documents produced by Amazon to law enforcement pertaining to an Amazon account associated with Kohberger. The documents include the order history between January 5th, 2022 and December 13th, 2022, and click history and sign-in history for specific dates in that time frame. The documents are referenced by Bates number. His supplemental disclosure identifies with specificity, sorry, it always gets me, the facts Mr. Cox will be testifying to from the identified documents. As with his challenge to Mr. Douglas, Kohberger asserts that Mr. Cox should not be able to offer any opinion because none are expressed in his disclosures. Again, Mr. Cox is a fact witness and will not be offering opinions on the documents apart from explaining what the documents show as outlined in his disclosures. There is no basis for exclusion. All right, girl, go for it.
Barnharts. Okay. Darren Gilbertson. Kohberger disclosed expert opinions from Brent Turvey that more than one assailant was necessary to accomplish the crime in the time frame alleged. Specifically, he asserts that 1, there is direct and indirect evidence that attempts were made by the suspect or suspects to clean up the crime scene after the homicides, which would have taken far longer than the time interval alleged by the state. And 2, there were multiple weapons used against Kaylee Goncalves, and Xana and Ethan appeared to have been attacked at the same time. Oh, there were multiple weapons used against Kaylee, and Xana and Ethan appeared to have been attacked at the same time. Through his other expert, I know we're going to have to go back a bit. So through his other expert, Rachel Orr, Kohberger has also submitted evidence that he suffers from
Stop.
developmental coordination disorder, which has resulted in deficits in fine motor dexterity and visual motor function. So let me jump back. So without more, the court has concerns about the relevance of this testimony, but Kohberger has not challenged it on this basis as of yet. The state submitted 2 disclosures for Mr. Cox, the initial and amended. Kohberger also asserts in the motion that Mr. Cox's testimony should not be allowed because, according to defense expert David Howell, far more information must be reviewed in order to attribute specific activity to a specific person or otherwise render an opinion about user behavior with forensic certainty. This argument is addressed. Okay. So his attorneys, Kohberger's attorneys, have argued in other motions that these deficits render it, quote, not possible for Mr. Kohberger to have acted with the speed and coordination required to commit these crimes in the time frame alleged by the state. However, this has not been disclosed as an opinion of any of Kohberger's experts. In rebuttal, the state disclosed Detective Darren Gilbertson, a lead investigator for ISP in this case. The disclosure indicates he will testify that he and other investigators conducted timed runs at 1122 King Road to gain an understanding of the approximate time needed to have carried out the homicides. A report of the timed runs is attached to his disclosure. It was performed to determine if one person could carry out the homicides. His opinions will be that, depending on the suspect's pace and route, he could have carried out the crimes in approximately 2 to 4 minutes. Kohberger argues Detective Gilbertson's testimony should be excluded because 1, the state has failed to disclose how Detective Gilbertson is an expert in timed runs. 2, the relevance is minimal. 3, important data, i.e. recordings, photographs, and notes of the experiment, was not disclosed. And 4, his opinion carries a risk of juror confusion and prejudice. On the prejudice issue, Kohberger claims that Detective Gilbertson was already familiar with the house when he did the experiment, and additionally, the house had been vacated. Kohberger also notes the house has been torn down, so he's not able to conduct his own tests. When Detective Gilbertson's opinions are relevant will depend on what Mr. Turvey and Dr. Orr opine to at trial. While Dr. Turvey does not specifically state in his report that one assailant could not have accomplished the murders in the short time frame alleged by the state, he infers as much through his opinion that there was evidence of cleanup efforts at the crime scene, which would have taken a significantly longer period of time. Further, while Dr. Orr's report does not opine as to what deficits in fine motor dexterity and visual motor function Kohberger suffers from, to the extent she testifies to these deficits at trial, it may render Detective Gilbertson's opinions relevant to rebut any inference that Kohberger could not have single-handedly committed these crimes in less than 15 minutes. The court has indicated in a separate order that there is no foundation at this point for Kohberger's assertion that his deficits in fine motor dexterity and visual motor function rendered it difficult or impossible for him to commit the crimes. So further, given Detective Gilbertson's role as the lead detective for ISP in the investigation, he is well qualified to offer his opinion on suspected movement throughout a crime scene. In addition, there does not appear to be a disclosure violation due to the lack of underlying data. It was a simple experiment consisting of timing Detective Gilbertson moving through the house at a slower speed and then at a faster speed. His routes were described as well his pauses to simulate the number of stab wounds each autopsy showed. Okay, hold on one second. So it was a simple experiment consisting of timing Detective Gilbertson moving through the house at a slower speed and a faster speed. His routes were described as well as his pauses to simulate the number of stab wounds each autopsy showed. It does not appear that there are any photographs or recording or any other data not already described therein. As for Kohberger's IRE 403 concerns, they are baseless. The state represents that there was no structural changes to the house when Detective Gilbertson performed his experiments. The fact that it was vacated or that Detective Gilbertson was familiar with the home, which would presumably allow him to conduct a faster timed run, is fodder for cross-examination, not exclusion. The state further notes that Kohberger stipulated to the house being torn down after Detective Gilbertson report was disclosed. Thus, any concern of prejudice in this regard is his own doing. Finally, Kohberger cites no basis for jury confusion. Consequently, Detective Gilbertson disclosed testimony will not be excluded or limited at this time. Wow. So they took the time to move through the house, simulate the act of how many stabs each victim, and how long it would take. And defense over here, and here is their best defense. He's not capable. He's not capable of doing that with his fine dexterity. Are you kidding me? That's the best defense. So even like the questions that I have as far as, well, the door being open, the door being shut, seeing Xana, it does not outweigh the questions I have with the coincidences with Kohberger. It really doesn't.
Yeah, and I'm just like, I'm over here stuck on this thing of how, okay, at the very top of this, when you started, it was number two. The multiple weapons used against Kaylee, Xana, and Ethan, they appear to be attacked at the same time. But I'm over here thinking the blood transfer from the weapon as you go in order of the
Oh
deaths
yeah.
and testing for that to be able to help
Determine the
determine
order.
the order. Yeah.
That's correct.
So, what in the hell were his experts looking at?
That's a great question. So what Shay is talking about is depending on the order of the kills, guys, they're able to determine by blood transfer. So victim 1, it's going to be victim 1's blood on it. Victim 2 is going to have a mixture of victim 1 and victim's 2 blood on it. Victim 3, so on and so forth. So they're able to really, it's pretty interesting. They're able to determine the order, among other things, but based on the mixture of the bloods. But at victim 3 and 4, it's, and given that they were in the same room, and I wonder if what is going to come out is both Ethan and Xana's blood was on one another. That's what I'm taking from that.
Possibly. But adding in Kaylee in there though, that doesn't make sense.
Well, think about what Steve just said. She had extensive wounds to her face. Another weapon could be your hand, or it could be something that would result in the injuries to the face.
Wow.
Yes, 1, 2, and 3 will be void of 4. But if 3 and 4 both have 3 and 4, you know what I'm saying? Which honestly, I think back to the whimper and the thud and the possibility that 3 was hit, 4 was gone to, and 3 was gone back to. And I'm trying to use numbers to try not to be insensitive. Go ahead. What were you going to say, Shay? Free Harley for him.
I think 3 is him, and that, from my understanding, and this is just from what we've heard, I think that to the neck, from what I've heard, would have been enough. I don't think he'd have to go back.
No. Well, this is just my opinion. 3 was hit to the floor. 4 was hit. 3 was gone back to. And now I don't think there was much to go back to, but I think there was sounds. Mm-hmm. And he on the way back out hit 3. And that way, if there is blood, both 3 and 4's blood on 3 and 4, the attack could be concluded happening at the same time if there was a mixture of both bloods.
Yeah. That's interesting, though.
Mm-hmm.
I really wish we could see the experts' reports. I know
Yeah.
we can't, but I am just so curious.
Well, I am curious about what stated as far as a cleanup. Was there a wipe? What was there a smear? What kind of cleanup are we talking about? Because again, we can't just jump. Okay, we can't in our mind, assume like, oh well, this is what it means. No, no, no. It could be something very minimal, like wiping, like one wipe indicates cleanup, right? So I'm trying not to jump too ahead, but I have to see more on that.
Well, what if it had something to do with kind of what Steve was talking about, like the lack, like
Yes.
trying to mitigate a
Wrap. That's
trail?
exactly what I was
Yeah.
thinking when I said that. I was like, okay, if he was potentially nervous that at that point when your adrenaline's rushing, there's 4 kills, you're not sure, did you get cut? Is any of this blood yours? The possibility to take maybe a shirt, let's just say, and do quick wipe, and wrap your hand with that K bar and then walk out. Something like that. That's why I said it could be something as simple as some of the blood was wiped real quick, um, not knowing if it was contained the killer's blood.
Interesting. And I tend to think that he like double wrapped his shoes, like
Mm,
had like
booties. Yep.
booties on booties, take one off, go to the next, take one off, go to the next.
Oh, you think booties on booties?
Yeah, think about it. You wouldn't like want to track that around.
Oh,
Booties on booties.
booties on booties.
Well, King, I think that when it comes to the car after the
Yeah.
interview, like with Steve and them, I think that makes sense. But in the house,
I can't
oh,
think in the house, but I think back to that kill kit, but I think it was a bag left open so before he walked out, he could take everything right off, but he probably didn't if Dylan saw him. But at least once he left the house, like right outside the house before getting in the car, if the car was lined with like the trunk was lined with a shower curtain, let's just say the shower liner, right?
yeah.
Putting everything right in that bag, taking the gloves off, taking the booties off, taking everything off, putting it in that bag, opening the trunk or putting on a new pair of gloves, clean pair of gloves that was in that bag, switching it out, opening the trunk, putting that bag in a lined trunk, then getting in the car, driving off, and with that tipped shovel, bury it.
Hmm.
Bury it. Yeah, poor Linda. Yep.
Wow.
Mhm.
Interesting. All right.
Yeah, Tori.
Huh.
Exactly, Misty. It's insulting. We don't know the specifics, Harper's Nana, but coroner said very early on, majority to their torso area, consistently their torso area. Good night, Pitty Mama. That could have been too,
And
Cicely, on
chest,
top of
yeah.
it. Hmm.
All right. You want me to go?
Oh yeah, I think I gotta open up a package of Gushers for this. So hold on before it makes a bunch of squeaks.
No, you're fine.
Let me tear this baby open. But I just put lotion on, so it's so hard. All right, now you can go.
Fine dexterity. It just cracks me up.
Yep. He wasn't capable. He could grade papers. He could go on 7-mile hikes or runs. He could stargaze. He could fucking actually perform these experiments in school in the labs. He could do all this, but no, he can't commit a murder. No.
No, not him. Gee, ISP forensic lab scientist. The state disclosed several forensic scientists from the ISP forensics lab to testify as experts in this case. The initial disclosure for each scientist describes subject matter the expert will discuss, including the particular evidence and the testing performed. The disclosures also reference each scientist's specific lab report by Bates number. In each disclosure, the state included the following caveat. The disclosure is provided as an aid. It does not encompass all findings, impressions, conclusions, or materials related to this expert's involvement in this case. It further does not in any way limit the scope of the expert's testimony. Further, this expert may testify about findings, impressions, and or conclusions that he or she drew from the work or other experts or work of other experts who previously examined or handled the evidence in question. After the defendant moved to compel more complete disclosures, the court advised the state to supplement accordingly. On March 3rd, 2025, the state did so largely by expounding upon the general subject matter of the experts' respective work. They did not add any new opinions. Kohberger now moves to limit the scientist's testimony in the state's case in chief to their lab reports. This limitation is not necessary. If the scientists testify to something that is not disclosed in their disclosures or lab reports, Kohberger can object at trial. There is no basis to prospectively limit their testimony now.
So Gary Dawson, Dr. Gary Dawson, was disclosed in rebuttal by the state to testify to, quote, the degree of impairment of the victims, particularly Madison Mogen, at the time of the homicide. His expert report attached to his disclosure opines that Maddie would have been, quote, markedly intoxicated from the effects of alcohol around the time of her death. She would not have the ability to mount a meaningful response to a sudden threat to her person. He further states that while he has limited his review to Maddie, the same general principles apply to the other victims. Kohberger seeks to strike his testimony on grounds that it is improper rebuttal. He contends that none of his experts have challenged her ability to fight back and otherwise contested her toxicology levels. The state responds that the opinion rebutes defense expert Brent Turvey's opinion that more than one assailant was necessary to accomplish the crime in the time frame alleged. Specifically, the state argues that evidence Ms. Mogen was unable to effectively fight back supports its position that one assailant could have completed the homicides in a short time frame. So, for example, where the initial disclosure stated the expert would testify generally about the collection of DNA. Okay.
Mm-hmm.
The court does not. Okay, it's all right. So rebuttal evidence is evidence which explains, repels, counteracts, or disproves evidence which has been introduced by or on behalf of the adverse party. Mr. Turvey has opined in his report that 2 assailants were involved in the homicide, partially because he believes multiple weapons were used against Kaylee Goncalves. Inferred in this opinion is that one person would not have had the time or ability to use multiple weapons in the time frame alleged when faced with 2 victims. If Ms. Mogen was intoxicated to the point of being unable to fight back, however, it would be possible for one suspect to incapacitate. Why does that sound weird, though?
It's sometimes when we're reading, it's like your brain just
Yeah.
isn't able, like we know it, I
I
can't do it with
know, but like
specificity.
it sounds weird. It sounds weird. Okay, so for one suspect to incapacitate her and then use. Sorry, I'm laughing because I got to the word and I just paused. Like, wait, how do I say that? Incapacitate her and then use multiple weapons in attacking Miss Gonzalez. So, however, whether Dr. Dawson's opinion is relevant depends on how Mr. Turvey's testimony unfolds at trial. Consequently, his disclosed rebuttal opinion will not be excluded or limited at this time. Got a brain fart there.
No, good.
I'm not sure, Thievy. Like, what do you mean? Like your messages or other people's messages?
I don't know.
See, I keep thinking about Steve saying not only that, she had a broken nose, but he kept saying there's more to it, but I'm going to wait. I'm curious if it's clear that those injuries are what's being indicated by another weapon. But
yeah,
A hand can be a weapon. The butt of the K-bar could be a weapon. There could be multiple things. And again, it's also indicating a big struggle, which could lead to that sheath falling out of said pocket or wherever it may have been.
Stevie, make sure that you're on all chat, not top chat. Maybe
Yeah.
that's why. Okay. No, sorry. I was like, wait, what? Ah, I really want to know what's in their multiple perpetrator and weapons thing. It's driving me nuts. I can't get over it, Melissa.
Mm-hmm.
Like I want to hear it all. Okay. You want me to go with you want me to do Lawrence Mowry?
Yeah.
Lawrence Mowry, Jeffrey Tanzola, and Neil Uhrig. Detective Lawrence Mowry, Agent Jeffrey Tanzola, and Detective Neil Uhrig are forensic detectives who were involved in the investigation of this case. Detective Mowry of the Moscow Police Department is disclosed to testify in the state's case in chief as an expert in the field of digital forensics and his role in the investigation. Specifically, he may testify to any of the subjects identified in his reports and may identify and testify to chain of custody, extractions, electronic data, files, and location records identified in the materials made available to Kohberger. And that was part of the initial disclosure. There are approximately 50 individual devices. Wow. Electronic accounts and digital data listed in the disclosures about which he will testify, and he will opine that he found no connection in that material linking Kohberger to the devices and data he analyzed.
Mm.
Jeffrey Tanzola is a special agent with the FBI who extracted, processed, and archived the contents of 7 identified digital devices belonging to Kohberger. His is disclosed to discuss in the state's case in chief the extraction, imaging, examination, processing, verification, transportation, and chain of custody of those devices. The disclosure references and appends his report of examination regarding his work in this regard. Neil Uhrig is a forensic examiner and a detective sergeant for the Post Falls Police Department who extracted, processed, and archived the contents of computers belonging to the victims and 2 other roommates of 1122 King Road. His case in chief disclosures likewise state he will discuss extraction, imaging, examination, processing, verification, transportation, chain of custody as to those computers, including the expertise necessary to extract the data from the devices. He'll opine that there was no connection found between the listed devices and Kohberger. His initial disclosure references and appends his officer report regarding his work in this regard. Kohberger argues that each of these 3 experts' testimony must be limited to what has been disclosed, i.e., the devices, data examined, and processes used. Other than the disclosed opinions by Detective Mowry and Uhrig that no digital connection was found between Kohberger and the residents of 1122 King Road. Kohberger argues no specific testimony regarding what the devices and data depicted should be allowed. To this end, Kohberger notes that the state has not identified in the disclosure the specific portions of the identified devices and data that these experts will testify to. In response, the state clarifies that it is not seeking to elicit opinions from these witnesses. Rather, it intends to elicit testimony about their qualifications necessary to perform the extractions and analysis of the identified devices and data. It further represents that Kohberger has been provided with all the data analyzed. There is no base to exclude or limit the detectives' disclosed testimony. It is clear that they will be testifying to the facts of their investigation, not providing traditional expert opinions. There is no need thereof for the detectives to identify specifically what the devices and data depict. This is factual in nature, and Kohberger has been provided with all of the material the detectives reviewed.
Okay. Rob Hill. So Rob Hill is a special agent with the FBI who reviewed surveillance footage from the hours before and after the homicides occurred, depicting what law enforcement believes is suspect vehicle 1. Agent Hill was disclosed to refute opinions by defense expert Stephen Becker that it was not possible to ascertain from the surveillance videos whether a front license plate was missing from the vehicle. Agent Hill's rebuttal references the full summary of video depicting suspect vehicle 1, which has not been disclosed to Kohberger, as a basis for his opinion that suspect vehicle 1 did not have a front plate. He then lists the specific camera locations and timestamps he contends show a clear view of a missing front plate. His rebuttal also states he will provide testimony about the significance of the missing front plate. Kohberger contends that since Agent Hill has not offered an opinion as to any videos other than those specific clips referenced, his testimony must be limited to those identified clips. However, Agent Hill's disclosed opinion is not restricted to the identified clips. It expressly based on the full summary of video of suspect vehicle 1, with the identified clips being the most clear. Thus, the court will not limit his testimony in this regard. So here's the order, and it's denied. Their order for the vague and undisclosed expert motion in limine denied.
Denied. Wow.
Okay. Ooh, I know what I'm pulling up next.
What?
Denying this damn death penalty getting thrown out.
Which one?
The autism spectrum.
Oh, are we ready to rage and chat?
Yep. Go ahead. Give us the introduction, Shay.
All right. Having been recently diagnosed with autism spectrum disorder, ASD, by a clinical neuropsychologist retained by his defense team, Kohberger seeks to strike the death penalty as a sentencing option, arguing it violates his constitutional rights. He contends ASD is the functional equivalent of an intellectual disability, which is categorically recognized as a disqualifying exemption to the death penalty. Even if the court rejects a categorical approach, he argues the death penalty option should nevertheless be stricken in this case, given the intense media attention on Kohberger's disability. In response, the state disputes that ASD is equivalent to an intellectual disability for purposes of a categorical exemption to the death penalty, and further notes that Kohberger has not shown a national consensus supporting such an exemption. As for Kohberger's individualized argument, the state contends that none of Kohberger's concerns warrant striking the death penalty. Oral argument on the motion was held on April 9, 2025, after which the court took the matter under advisement. The court finds striking the death penalty is not warranted.
So the standard is, just the case law. So we have the facts. So during the course of this case, the defense team retained Dr. Rachel Orr, a clinical neuropsychologist, to conduct a comprehensive neuropsychological evaluation of Kohberger and issue a report. As part of this evaluation, Dr. Orr interviewed Kohberger's immediate family members, and other relevant adults from Kohberger's childhood, including former teachers. She gathered information on Kohberger's history, made behavioral observations, and administered cognitive tests. Based on her evaluation, Dr. Orr diagnosed Kohberger with autism spectrum disorder level 1 without accompanying intellectual or language impairment. According to Dr. Orr, ASD is a complex, heterogeneous neurodevelopmental disorder rooted in brain differences and characterized by social and behavioral features. It causes, quote, deficits in which affected individuals perceive and react to others and their environment, causing problems in social communication and interactions, repetitive behaviors, and narrow range of interests. There is a wide range of autism symptoms and severity. Deficits can include a restricted range of affect, atypical eye contact, displaying facial expressions or movements that do not match what is being said, failure to consider social cues, having trouble with speech reciprocity, and repetitive behaviors. Pursuant to the American Psychiatric Association's Diagnostic and Statistical Manual, There are two primary, okay, I'm not going to go through what that is. It's just like what the standards are for diagnosing. So the severity of ASD is based on these two criteria. There are 3 levels of severity, which correlate to how much support is needed. Level 3, which is the most severe, requires, quote, very substantial support. Level 1, the least severe, requires merely support. As to the first criterion, Dr. Orr noted in her report that Kohberger's family and peers reported that Kohberger displayed atypicalities and difficulties in social settings dating back to early childhood, including 1. Inability for Kohberger to adjust his behavior to suit the social context. 2. Poor social reciprocity in conversation. 3. Issues with nonverbal behavior like personal space. And 4. Limited ability to take perspectives of others. She notes that these difficulties played a role in the eventual termination of his funding for his graduate program. At the time of his arrest, he was pursuing a PhD in criminal justice and criminology at WSU. In her personal evaluation of Kohberger, Dr. Orr observed that Kohberger demonstrated some typical social behaviors, such as, quote, fairly consistent through intense eye contact, polite demeanor, and social conventions, shaking hands upon greeting. He engaged in conversation and was never overtly inappropriate. However, Dr. Orr also noted social behavior consistent with that reported by others, such as lack of fluidity in his verbal interactions, awkward comments or abrupt responses, quote, inconsistent understanding and acknowledgement of humor, and occasional intense gaze. She noted that he had poor reciprocity of interaction, including very frequent refocus of conversation back on his own experiences or unusual responses to my sharing. She also noted his lack of close friends and his poor insight into his role in relationships. Dr. Orr observed deficits in Kohberger's nonverbal communication, noting, quote, poor integration of verbalizations and eye contact, limited use of descriptive gestures, restricted range of affect, atypical tone. As to his speech, Dr. Orr observed that Kohberger was generally clear articulated and his speech was appropriate in rate and volume, but overall monotone. His language was generally appropriate in content and form with an extensive vocabulary, but overly formal, often over-inclusive and disorganized and highly repetitive with frequent scripted phrases. By way of example, Dr. Orr noted that Kohberger often used the phrases, quote, objectively speaking, mind you, to be fair, and moral of the story. As to the second criterion, Dr. Orr found Kohberger exhibited all 4 of the behaviors. He engaged in, quote, occasional subtle rocking of his upper torso while seated and scripted and repetitive language. He appeared fixated on the routine or timing of breaks and procedures during the examination. He also demonstrated rigidity in his thinking and behavior, preservative ideation, wanting to know the results of his testing, and was highly interested in circumscribed topics such as forensic psychology, intellectual topics, and Murakami. She also noted that he was highly distracted by sounds or activity occurring around him and frequently looked from side to side to monitor his periphery. As a result of being easily distracted, he needed instructions repeated to him. Defendant's neuropsychological profile revealed a high average intellect at baseline, and his full-scale IQ score was 119, which is in the 90th percentile for his age. Cognitively, Kohberger showed strong verbal abilities, abstract reasoning, memory, concept formation, and reading skills. However, he displayed weakness in executive functioning, such as planning, cognitive flexibility, impulse control, and organizational approach. He tended to perceive information in a piecemeal manner rather than look at the whole picture. Ultimately, Dr. Orr found Kohberger was clearly a neurodivergent individual, manifesting all the social and behavioral features of ASD. As noted, Kohberger was assigned a level 1 diagnosis without intellectual impairment, which is the least severe level. You want to continue?
Yeah.
This is, I'm
Doc-
sorry, but welcome to at least 50% of the population.
Yeah, I was reading the subscript at the bottom of page 3, and it said that Dr. Orr noted that Kohberger commented that he had a lot of fun completing a cognitive test.
Oh my God. And when I read the part where he wasn't able to gauge when to laugh. What the fuck are you joking about regarding quadruple homicide and evaluating him?
Oh my Lord. Okay, so Dr. Orr noted that the defendant's social smiling was inconsistent and occurred in unusual and incongruent context. She also noted he did not display tearfulness, anxiety, or anger. Interesting. Okay. So, Dr. Eileen Ryan, a board certified psychiatrist retained by the defense team, agreed with Dr. Orr's ASD diagnosis after conducting a comprehensive forensic psychiatric examination of Kohberger. Of note, she observed that Kohberger is highly intelligent and has a factual understanding of the proceedings against him, the penalty he is possibly facing, pleas, and the role of courtroom personnel. She further noted there was no evidence of a formal thought disorder or thought disorganization. Wow. Okay. So this gets into the analysis. Kohberger seeks to have individuals diagnosed with ASD categorically exempt from the death penalty. He contends a categorical exemption is warranted for individuals with ASD because, one, they are insufficiently culpable, and execution would not satisfy the retributive and deterrent purposes of capital punishment. Two, execution of individuals with ASD is contrary to the evolving standards of decency. And three, death sentences for individuals with ASD are inherently unreliable due to their inability to present meaningful mitigation evidence. Alternatively, he argues removal of the death penalty as a sentence option in his case is warranted due to the impact his ASD will have on his ability to present a meaningful defense, particularly given the intense media attention on his disability. A. Categorical exemption from capital punishment for individuals with ASD is not warranted. The Eighth Amendment provides excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. That's according to the U.S. Constitution. It gets into Atkins as well. So it says, at issue here is the first category in Atkins. The court held, okay, that gets into Atkins. Let me keep
Right here,
going.
no court.
No court has ever found ASD to be a categorically death disqualifying diagnosis. However, Kohberger argues ASD is the functional equivalent of an intellectual disability, and therefore the rationale underpinning Atkins applies with equal force to individuals with ASD. He further argues that categorically excluding individuals with ASD from capital punishment is consistent with society's prevailing standards of decency. The state responds that a categorical exemption from the death penalty is only available under the law to those with intellectual disabilities, the definition of which ASD fails to satisfy. It further disputes that there is any national consensus supporting Kohberger's claim. The state is correct. First, intellectual impairment, a hallmark of an intellectual disability, is not present in the diagnostic criteria of ASD, and no court has ever found the two to be equivalent. Second, Kohberger has not presented any evidence of a national consensus as to whether the death penalty is a disproportionate punishment for individuals with ASD. One, ASD is not equivalent to an intellectual disability for purposes of death penalty exemption. This goes through the law. So, sorry. So relying on, geez, sorry, this is a lot of law.
Yeah, it is. So in Atkins.
Well,
so intellectual deficiency, however, is not among the diagnostic criteria for ASD. Okay, you could right here further.
Further, even if adaptive deficits alone could give rise to a categorical exemption, Defendant has presented no authority that the adaptive deficits of ASD has the equivalent effect on culpability or on the ability to make a persuasive showing of mitigation, as does an intellectual disability. He dedicates a large portion of his briefing to describing how individuals with ASD, like those who are intellectually disabled, struggle to present meaningful mitigation evidence due to their adaptive deficits. He contends they are less able to meaningfully assist counsel due to social and communication deficits and their tendency to focus on specifics rather than the whole picture. He argues that the flat affect and other physical manifestations of ASD can create an unwarranted impression of lack of remorse, and further, awkward speech and distractibility render individuals with ASD poor witnesses. He also contends that evidence of ASD is double edged because it will likely be perceived by the jury as aggravating rather than mitigating. However, to even be considered for categorical exemption from the death penalty based on these adaptive impairments alone, Kohberger would, at a minimum, have to demonstrate that, considered as a whole, individuals with ASD suffer from these same or similar impairments that render them more susceptible to false confessions and diminish their ability to assist in their defense, which it's then starting to quote Atkins. Indeed, as the name implies, it's on a spectrum. Some may suffer from adaptive deficiencies to a degree where it interferes with the presentation of mitigation evidence, and some may not. The lack of any uniform presentation, which can be measured on an objective scale, like IQ, youth, and competency, renders ASD inapt for categorical exemption. Further, courts have considered whether to extend Atkins to mental health disorders similar to ASD, have uniformly declined to do so.
You don't have to do the example.
Yeah. Oh, but hold on. What is this? They gave
You
us
could do this
this.
10.
Yeah. So in the subscripts, indeed, Kohberger is an example of a highly functioning individual with ASD. His diagnosis is not accompanied by an intellectual or language impairment. He has an IQ of 119 and graduated from his master's program with a 4.0 GPA. At the time of the homicides, he was enrolled in the doctoral program. His experts describe him as highly intelligent, having strong verbal abilities, abstract reasoning, memory, concept formation, and reading skills. They noted no evidence of a formal thought disorder or thought disorganization. He understands the proceedings against him and the penalty he is possibly facing. He is generally clearly articulated and demonstrated some typical social behaviors, such as fairly consistent, though intense eye contact, polite demeanor, and social conventions. There is no indication he is susceptible to a false confession, nor is there anything approaching a confession in this case, to the court's understanding. In fact, Dr. Ryan notes that Kohberger continues to adhere rigidly to a belief that he will be found not guilty. While he is noted to having a flat affect and other physical mannerisms that could potentially be interpreted by the jury as a lack of remorse, Atkins demands more of a reduced capacity than this. Further, any danger that the jury will interpret his affect as a lack of remorse can be mitigated by addressing ASD and voir dire, and through expert testimony and evidence in the penalty phase.
I got like a nerd cluster chilling in my throat somewhere, and like it keeps tickling it.
You're eating a lot of sweets tonight.
Shut up. let me put this away.
I've never heard of you to eat that many sweets.
Because Wolfie sent me a snack pack a couple of nights ago, and it included Gushers nerd clusters for me to try for the first time. And my dog's
I love nerd clusters.
Yeah, I've never had them. So technically I've only had probably 8 cluster balls since I've opened it, which they're very tiny. So don't freaking judge me, Shay. But if I'm going to sit here and we're going to read so much, I need to do something.
I do not judge you. I will buy a bag of those nerd clusters and eat them all in one night.
Yeah, but there's one stuck somewhere.
All right. You can drink and I'll read. Okay.
Yeah, go ahead. I'm going to mute.
You're fine. So this goes through some court stuff. So in sum, the defendant has not demonstrated nor has any court held that persons with ASD have similar cognitive and behavioral deficiencies that result in equivalent diminishment of culpability, ability to be deterred, and capacity to assist in their defense as individuals with an intellectual disability. While they may share some similar adaptive deficiencies, Kohberger has not demonstrated how this alone establishes equivalence of Eighth Amendment purposes.
So I
Two,
stick to my dots.
you,
So I stick to non-sweet shit. You see,
I
if I
know.
died, just know it was Wolfie.
I blame Wolfie. She's already probably asleep.
Cheese and rice, man. Like, I don't know how to get it out. Like, just one loose nerd. How do I get it out?
I don't know. I just try to clear my throat.
Yeah, I keep coughing, and it's there. It's somewhere. Okay, keep reading.
All right, you want to scroll down because I'm going to go down to number 2. I have it up on mine, so I can keep going. 2, the defendant has not established a national consensus against execution of individuals with ASD. So for Eighth Amendment purposes, cruel and unusual punishment is defined by evolving standards of decency that mark the progress of a maturing society. This is getting into death penalty, so we're going to go down to page 12. Kohberger argues categorically excluding individuals with ASD from capital punishment is consistent with society's prevailing standards of decency. He notes that the psychological community's understanding of the manifestations of ASD has significantly evolved over the past 40 years, bringing with it a marked explosion in both ASD diagnoses and increased societal awareness. He points out that this growing awareness of ASD has coincided with efforts by the criminal legal system to address mental health disorders through the creation of mental health courts. He further notes that evidence of ASD has been held to be relevant in criminal cases to issues of intent. As for legislative enactments, he points to 2 states, Ohio and Kentucky, which recently enacted legislation barring people with serious mental illness from being sentenced to death. At best, this evidence demonstrates a growing societal sensitivity to mental disorders generally. However, evidence of evolving standards of decency must come from legislative and executive actions. 2 states protecting individuals with severe mental illness from execution is not a national consensus. Further, these 2 states' statutes only apply to schizophrenia, schizoaffective disorder, bipolar disorder, and delusional disorder, not ASD. That's good to know. So, moreover, the courts, including the Idaho Supreme Court, continue to reject the notion of a national consensus in this context of mental illness. Perhaps recognizing the lack of legislative acts in support of this argument, Kohberger attempts to show a national consensus against executing individuals with ASD through a handful of court decisions finding the diagnosis to be of evidentiary value. None of these, however, are capital cases. He also cites to recent media attention on a Texas capital case against Robert. Oh yeah, I know about this one. Against Robert Robertson, an autistic man who was convicted of killing his baby on a theory of shaken baby syndrome. Mr. Robertson is seeking to commute his death sentence based in part on the argument that his ASD contributed to his conviction. Um, so the defendant notes that a group of 84 Texas legislators recommended clemency for Mr. Robertson. However, what Kohberger fails to mention is these legislators did not recommend clemency due to his autism, but because of his significant scientific and medical evidence now shows that his daughter, Nikki, who was chronically ill, died of a combination of natural and accidental causes, not the debunked shaken baby syndrome hypothesis that the state used to convict him. In sum, not only has Kohberger failed to show that ASD is equivalent to intellectual disability for death penalty exemption purposes, he has not shown that there's a national consensus against subjecting individuals with ASD to capital punishment. ASD may be a mitigating factor to be weighed against the aggravating factors of determining if if a defendant should receive the death penalty, but it is not a death penalty disqualifier. Oof.
I'm alive.
I'm almost done. I'm going to finish this one out.
Go ahead.
All right, B. Case-specific factors do not warrant the defendant's exemption from capital punishment. Kohberger alternatively argues he should be exempt from the death penalty because the intense media scrutiny on his ASD undermines his ability to present a meaningful defense and renders it impossible for him to receive a fair, individualized sentencing determination. He points out that the news sources have focused on his social deficits, including his past interactions with females, his deadpan look, robot like walk, cold iciness, rigid posture, and lack of facial affect. He argues the media is demonizing him for his disability while at the same time emphasizing the brutality of the crime. This, he warns, will overpower any mitigating arguments based on ASD and poses a risk that he will be sentenced based on his disability. As the state points out, however, there is no precedent for striking the death penalty due to media coverage. Further, any concerns that arise from such media coverage can be mitigated through voir dire and from expert testimony and evidence through the penalty phase of the trial. Order. Based on the foregoing, defendant's motion to strike the death penalty regarding autism spectrum disorder is denied.
Denied.
Oof. Denied. Thank God.
Okay. I'm trying, and I'm alive. I'm okay.
You gonna be all right?
Yeah, I think I'm gonna be all right. It was closed there for a second though. Let me.
Oh my goodness.
What?
What is this one?
What?
We need, oh gosh, but we got to read that top one.
That's
Or
the
the,
one we just.
no, the strike the death penalty and adopt other necessary.
That's the one I just pulled up. I have that. That's what I was gonna do because I was like, all right, we just read this one. We should go for this one.
Oh yeah, we're on the same wavelength.
Here we go. So this is when Anne was like, listen, if you're not gonna throw it out and strike the death penalty because he has ASD, you could at least do it because I haven't even gone through all the discovery yet, which when he asked if you were on the path and you had enough time, you said yes, and you've since taken on another death penalty case, which why would you do, and you're saying, well, he would have ineffective counsel if you give him the death because I don't have this time. Bullshit.
You're curious about the way we pronounce the jury selection
Yeah, I was
process?
reading that. I pronounce it jury selection process. How do you pronounce it?
Are you talking about like when I said voir dire or voir dire?
I don't know.
Oh, okay. Yeah.
Oh, the dire.
Yeah, I know it's pronounced differently. I think also it could be regional. I even heard like Emily D. Baker talking about that, like saying it differently in Cali versus other areas.
Mm-hmm. Voir dire.
Are we ready to see Anne have a fit?
Mm-hmm. So this is the order on defendant's motion to strike the death penalty and adopt other necessary procedures. So Kohberger contends that the discovery produced by the state in this case has been voluminous. What? Help me? Voluminous. Oh, my brain's
like voluptuous, but voluminous. Like
help. It's the nerd. I'm gonna blame the nerd for that one. And unorganized, thus rendering him unable to meaningfully review and investigate the state's evidence in time for a trial. Asserting his due process rights have been violated, Kohberger seeks sanctions in the form of striking the death penalty and imposing certain organizational requirements upon the state to aid Kohberger's review of the discovery. The state responds that it has complied with all the discovery obligations, including Brady, and there is no basis for sanctions or other measures. Oral argument was held. Court took the matter under advisement. Because Kohberger has failed to show a discovery violation or due process violation by the state, sanctions are not warranted. court further declines to require the state to provide further organizational assistance to Kohberger. So the standard, which we don't need to go through the standard, but the analysis pursuant to Brady versus Maryland, a prosecutor has a constitutional duty to disclose favorable evidence to the accused where such evidence is material, either to guilt or to punishment. This duty covers not only exculpatory material, but also information that could be used to impeach a key government witness. Brady does not, however, grant broad discovery rights to a defendant. It simply imposes a due process standard upon prosecutors by requiring them to disclose favorable material evidence. So in tandem with Brady, the Idaho criminal rules requires the prosecuting attorney to disclose as soon as practicable following the filing of charges any evidence which, quote, tends to negate the guilt of the accused as to the offense charged or which would tend to reduce the punishment. The discovery obligations under both Brady and ICR 16 extend to all the government agents having a significant role in investigating and prosecuting the offense. Kohberger complains that the state has failed to satisfy its obligations under Brady and ICR 16 due to its method of discovery production. He contends that the state has turned over more than 68 terabytes of data in discovery, consisting of in excess of 13,000 photographs, 15,000 video clips from businesses, and 8,000 video clips from residences. It also includes more than 60 digital devices, digital data, and search warrant return data. Kohberger also contends the state has not provided the discovery in a searchable format, has not provided detailed logs and indexes that would facilitate defense's review of the material, and has not specifically identified any Brady evidence. Kohberger argues he has not been prejudiced by the state's data dump method of discovery and contends that sanctions are warranted in the form of striking the death penalty and excluding the witnesses. He also asked that the court required the state to identify Brady material or hot documents within its discovery, aka do the job for me. While the state acknowledges there is a massive amount of data in this case, it contends the majority is completely irrelevant. Specifically, the state contends that most of the data is from cell phone extractions and weeks of surveillance video footage throughout the Moscow area obtained following the homicides. It affirmed on the record that it is unaware of any Brady material in those videos other than those specifically identified in motion practice and otherwise throughout the case. Further, the state's experts who reviewed the various devices, including cell phones and other digital data, have disclosed opinions that they found no connection between Kohberger and the victims from the devices and data. The state also notes that since this case began over 2 years ago, it has continuously turned over to Kohberger all the information it received from the various investigating agencies in the same format as the information was received by the state. This was done at Kohberger's request, who specifically asked the state to produce everything the state had from the get-go. Kohberger also issued 400 itemized requests for discovery in this case. Thus, the state contends it is on the same playing field as Kohberger regarding the discovery. In addition, the state points out that on September 4th, 2024, at approximately the same time as its discovery deadline, it provided Kohberger with a 320-page index identifying the location of requested discovery, a description of the evidence, and the date discovered. In addition, all of the evidence received from the FBI, which comprises the majority, was provided to Kohberger with a searchable index. In sum, the state asserts it has provided everything required by ICR 16A and Brady and disputes that it has engaged in any discovery violations. You want to go?
Yes. Defendant has not established a discovery violation, thus sanctions are not warranted. There are 3 components of a true Brady violation. The evidence at issue must be favorable to the accused, either because it's exculpatory or because it's impeaching. That evidence must have been suppressed by the state either willfully or inadvertently, and prejudice must have ensued. Kohberger, as he appears to have acknowledged at the hearing, cannot establish these elements because he has not identified any withheld evidence that is exculpatory or impeaching. Further, he has not identified any obligation under ICR 16 that the state has violated. His quibble, rather, is with the method in which the state has produced discovery, arguing it is effectively a data dump that prevents him from meaningfully reviewing the discovery for Brady material. There are, however, several problems with Kohberger's position.
Give it to us.
First, while neither Brady nor ICR 16 prescribe the form discovery must take, it is well settled under federal law that there is no direct obligation for the government to identify or itemize Brady material for the defense. So I'm gonna keep going.
Yes.
Go ahead and stay on. So apparently it says that like he tried to like suggest to the state that they use some kind of evidence software program. That's what I saw in like the subscripts. So furthermore, voluminous discovery alone is not a basis for finding concealment under Brady. This occurs typically in open file discovery where the government effectively makes its entire file available to a criminal defendant. The method of discovery which Kohberger requested of the state in this case carries the recognized benefit of increasing the efficiency and fairness of the criminal process. It is only when the government uses the open file policy to hide exculpatory material or otherwise prevent a defendant's access to such material that a Brady violation will be found. And then it gives a small example. However, where there is no proof that the government larded its production with entirely irrelevant documents or made access to documents unduly onerous, a Brady violation will not be found. Here, Kohberger has not shown any bad faith by the state with regard to discovery production. While discovery is indeed voluminous, the court does not find that the manner in which the state produced it violates Brady or otherwise constitutes misconduct. The discovery was produced to Kohberger as he specifically requested. The state received the information from its investigating agencies, labeled the materials, and turned them over to Kohberger through a shared access drive in the same format as received. This method not only puts the state and Kohberger on equal footing regarding discovery review, it also serves the important purpose of protecting against claims of missing or manipulated documents if the state puts them in a different format or organization or otherwise conveys them to the defendant in a different manner than received. While the state acknowledges that much of the discovery is completely irrelevant, including surveillance videos and data from the numerous phones, computers, and other devices, it did not produce it for purposes of padding the file or otherwise attempting in bad faith to hide Brady information in its haystack of information. Rather, Kohberger asked for everything, and everything is what he received. Kohberger cannot demand everything under the sun and then complain about the weight of all the planets. I love that.
Yep.
I love that. Okay. Moreover, Kohberger has not produced any evidence showing that the state has hidden Brady material or made his access to discovery unduly onerous. Although the state did not provide all the discovery in a searchable format, as it was not received by the state in such a format, it provided a 320-page index identifying the specific location of evidence produced in response to Kohberger's 400 individual discovery requests. 400, guys. Wow. Oh. A description of the evidence. I was like, you know what? Like maybe spend less time like on your 400 discovery requests and start reviewing the fucking material. Okay.
Yep.
Sorry. And the date discovered. In addition, the discovery received from the FBI, which comprised the majority, was provided to Kohberger in a searchable format. Other than the cell phone digital data and video surveillance footage, Kohberger has not identified what information his counsel will be unable to review prior to trial and why that information is material. Further, the state has stipulated that it is unaware of any Brady material in the video surveillance footage other than that specifically identified in motion practice. And its experts who have reviewed all the cell phone and other digital data in the case have opined they found no connection linking Kohberger to the devices and data analyzed. In addition, Kohberger's complaints of being unable to meaningfully review the discovery ring hollow. Kohberger has been receiving discovery in the same manner for over 2 years. In that time, he has not once sought a remedy from this court to regulate discovery, such as requiring the state to provide discovery in a different format. He has not sought additional resources under Idaho law to hire additional staff to review discovery or obtain litigation document control software to help organize and sort the evidence. His lead counsel insisted that she be allowed to take on a second high profile capital case despite the voluminous discovery in this case. Further, at oral argument, lead counsel indicated that her practice is to personally review all the discovery herself rather than rely on associates and staff to review materials to cut through the less relevant information and point to what materials need review by lead counsel. These actions are not indicative of an overburdened defense team. In fact, it is evident Kohberger has been able to capably navigate the discovery given his more than robust motion practice, the scope and breadth of the experts retained, and the disclosures filed. In the cases cited by Kohberger, where the courts have struck the death penalty as a sentencing option, the defendant has demonstrated that the prosecution either willfully or inadvertently, but with extreme resulting prejudice, violated discovery obligations. Here, however, Kohberger has not established a discovery violation under Brady or ICR 16 in the first place. He has not shown the state has attempted to conceal specific materials within the discovery, and he has not shown discovery to be unduly burdensome to the point where he is unable to examine the items that are material and of evidentiary value. Consequently, there is no basis for any sanction, let alone striking the death penalty. I didn't know if there was anything in the subscripts. I don't think so. I think they gave an example of what Lori DeVallo. Okay. Yeah. Not much.
The court declines to impose organizational requirements on the state. Kohberger additionally asked the court to require the state to identify Brady material or hot documents within its discovery. The court finds neither is warranted. Excuse me, we do not need to do your job for you. While the general rule is that the government need not specifically identify Brady material within a large mass of disclosed evidence, courts will sometimes order the government to organize voluminous discovery to comply with the spirit of its statutory and constitutional obligations. Such organization measures include requiring that the government specifically designate any known Brady material within the discovery. Whether to order such identification is highly dependent on the facts and circumstances of the case. So courts consider not only the volume of discovery and how it was produced, but the relative position of the defendant requesting identification, such as a defendant's access to counsel, whether the defendant is incarcerated, a defendant's access to resources, the defendant's ability to participate in the preparation of his own defense, and whether the interests of multiple defendants are aligned. So then it's just case law. So while Kohberger is currently incarcerated, he has a robust defense team and has not faced time constraints given his speedy trial waiver, with this case well over 2 years old. Further, unlike in Safarina and Salyer, Kohberger has had nearly as much time as the state to review discovery. Kohberger was arrested on December 30th, 2022, approximately 6 weeks after the homicides. Defense counsel filed a notice of appearance on January 12th, 2023, and the state first began providing discovery on January 18th, 2023. Thus, this is not a situation where the state has had the benefit of a years-long investigation compared to a defendant who has mere months to review the investigative material. Further, the court shares the significant concern voiced in Meek that requiring the state to identify Brady material in already produced discovery or to organize it in a way different from how the state received it would simply invite future litigation as to whether the state did a sufficient job. Not infrequently, what constitutes Brady material is fairly debatable, where the circumstances do not, as here, cry out for a departure from the general rule. The court will not invite such further disputes. In addition, there is no need to require the state to disclose a list of hot documents, which is a tool imposed by some courts for particularly voluminous voluminous discovery to aid the defendant in identifying material that deserve closer attention. So the state has effectively already done so. Kohberger was indicted by a grand jury. This process required the state to present evidence supporting the elements of the charges and identify any, quote, substantial evidence which directly negates the guilty of the subject of the investigation. Kohberger is privy to all of the evidence produced by the state at the grand jury proceedings in this matter. Further, the state recently disclosed its exhibit and witness list identifying precisely what the state intends to use to support its case. Additionally, the state has taken reasonable steps to aid Kohberger in navigating the discovery, including by 1. Providing a detailed index of all the discovery produced, identifying the location, a description of the evidence, and the date discovered. 2. Providing the FBI materials with a searchable index. 3. Working with counsel to resolve access problems to documents. And 4. Representing that the surveillance videos other than the loose highlighted by the state do not contain any relevant footage, and that the devices, phones, and other digital data of the victims and others do not show any connection between the defendant and the victims. Collectively, this provides Kohberger reasonable means to meaningfully review the discovery he requested. Consequently, the court declines to impose additional organizational requirements. Based on the foregoing, Kohberger's motion to strike the death penalty and adopt other necessary procedures due to the state's disclosure violations is denied.
It sounds like Anne doesn't know how to delegate and pass stuff down.
See, the court continues to strongly urge defense counsel to request additional resources and personnel from the money judge if it is felt needed, which he offered.
Wow.
Yes,
Well,
I agree. Yep. Okay, let me try to pick one more out at least for tonight. Let me see. What are we gonna do? Ouch. Sorry.
you're okay.
Ow.
Is the touch one contact DNA, is that one too long?
How long is it?
It's 15, but
Okay.
it's got a lot of stuff that we may be able to kind of skim over. It just actually this one it's just kind of talking about her being qualified to give her expert testimony. I don't know. I mean,
Is it interesting? Using the standard.
not really. I mean, I think it's something we've already gone through a few times with her stuff. Not that it's not interesting to me,
Yeah,
but
no,
it's
I know. Like a lot of them are very repetitive.
yeah.
Oh, this is like nothing. This is just an extension for the time. Requested jury instruction. No, that's nothing too.
I mean, I get.
Phase 1 lay witness. No, that's
I mean,
nothing too. All these all little short ones.
yeah, I heard it all about like the DNA transfer and discussing that and going against like some of the rebuttal testimony.
Wait, we read all of the 18th ones. Oh man, we're like almost caught up. We are like caught up. Shit. I get upset. Shit. Well, this is just damn. This is the motion to seal state's motion for examination of Kohberger's pursuant to Idaho. Okay. An extension of time to complete rebuttal penalty phase expert disclosures and declarations and exhibits in support. So prosecuting attorney moves the court for an order sealing the state's motion for examination of Kohberger and for an extension of time to complete the rebuttal penalty phase expert disclosures, as well as the declarations provided in support of this motion. So the exhibits reveal personal private information of Kohberger and affects his privacy interests. Specifically, the filing reveals mental health information about defendant, including psychological, psychiatric, and neurological information and diagnoses of Kohberger. The filing also reveals the nature of mental condition examinations already conducted and the type of examinations and testing the state seeks to perform, some of which is personality testing, to which Kohberger objects. In addition, the state has redacted the name of the psychology expert who is longer working on the case. The court should accept the redactions to protect the privacy interests of this individual. And then
Do you see who filed this one?
What?
Do you see who filed that one?
William W.
No, Mr. Hurwitz.
Hold on, wait. Oh, Josh!
Yes, Josh has made an entrance.
Josh! Oh, that's interesting.
Joshy poo.
She doesn't want help because Hippler offered her, you want 6 paralegals, you want 9 paralegals, you want me to throw it all at you? No problem. And Anne's like, well, but yeah, that would help, but not really help because they don't know what to look for. They can absolutely help you get through that discovery. Majority of it is useless. You're telling me that they can't help you go through hours and hours of footage, and you tell them, hey, if this pops up or that pops up, mark it down so I can then review those portions.
Yeah, that's why I was saying, like, she obviously has an issue with control and being able to delegate, you know?
Right. And so then they did seal the state's motion. Just, I don't need to pull it all up, but they did seal it. So I guess we could just go back to that one because it looks like Rylene is the one that is that the only one we didn't?
And the family member one on the 16th that I told you about. That one's very short. That's
Okay.
like a 3-pager.
Here, go ahead. Oh, I don't like being caught up. I like going through all of them. Okay.
All right. The state requests an order pursuant to Article 1, Idaho Constitution, allowing immediate family members of the homicide victims to be present during the entire trial, regardless of whether they are scheduled to testify. Attached to the state's motion as Exhibit S1 is a list of those individuals the state considers to be immediate families under the foregoing provisions. They are siblings, parent, grandparents, and step-parents of the deceased. Kohberger stipulates that the individuals listed in Exhibit S1 may remain in the courtroom during trial, but asks that the court provide guidance as to the proper courtroom decorum to discourage family members from wearing clothing or apparel that could be viewed as coercive by the jury. The state agrees that the court has the discretion to issue rules regarding courtroom decorum. At the appropriate time, the court will exercise its discretion in this regard. However, in his response to the state's motion, Kohberger requests that his immediate family members, siblings, and parents be allowed in the courtroom, arguing their exclusion would violate his Sixth Amendment right to a fair trial. The state objects on grounds that while family members of homicide victims have a constitutional and statutory right to attend trial, there is no comparable provision for a defendant's family members. The state also contends that it intends to call members of Kohberger's family as witnesses at trial and will ask the court to exclude any testifying witnesses from the courtroom pursuant to Idaho law. The United States Supreme Court recognized that the right to a public trial afforded by the Sixth Amendment entitles a criminal defendant at the very least to have his friends, relatives, and counsel present, no matter with what offense he may be charged. Courts recognize that having a defendant's family members present at trial advances the value served by the right to a public trial, i.e., ensuring fair proceedings, reminding the prosecutor, and judge of their grave responsibilities, discouraging perjury, and encouraging witnesses to come forward. However, like other constitutional rights, a defendant's right to a public trial is not absolute. The right to an open trial may give way in certain cases to other rights or interests. A partial closure of a trial, one that excludes a limited number of persons for either the entire or part of trial, is permitted if there is an overriding interest for the closure and the closure is narrowly tailored to serve the interest. Here, the purpose for the closure requested by the state, which provides in relevant part that at a party's request, the court may order witnesses excluded so that they cannot hear the other witness's testimony. This is a discretionary decision. While court is sensitive to the state's concerns about allowing testifying witnesses present during trial, the court is also sensitive to the fact that it is anticipated to be a lengthy trial and that Kohberger would like the support of his family. Further
Up. You muted. Well, you didn't mute. You left. Well, you didn't left. You're here. Oh my gosh. You're here. You're not muted, but like you're not here. See, it did it again at the 2.5 hour mark. See?
every time, isn't it weird?
Every time. It's like, enough, Shay, go to bed. That's what it's saying. Your phone limits you.
Oh, I'm on the iPad. It's like anytime I'm on the iPad, it does this. I'm sorry.
Aw, thanks, King Scarlet. That's okay.
Okay, a partial closure of a trial, one that excludes a limited number of persons for either the entire or part of a trial, is permitted if there is an overriding interest for the closure and the closure. Okay, I already read that part. Sorry. While court is sensitive to the state's concerns about allowing testifying witnesses present during trial, the court is also sensitive to the fact that this is anticipated to be a lengthy trial and that Kohberger would like the support of his family. Further, the scope of his family members' testimony is likely going to be limited. In an effort to reach a solution that upholds the rights of both parties, the court will require the state to submit for an ex parte in camera review a list of the Kohberger family members it intends to call at trial and the purpose for calling each of them. The state must also identify why each family member cannot be called very early in its case in chief and articulate why exclusion of the family member is necessary under Idaho law, particularly given the unprecedented publicity of this case, which has made much of the evidence available to those who wish to know, including the proposed Kohberger family witnesses. The state must submit these materials no later than April 25th, 2025. The court will provide the parties with this discretion at or before the pretrial conference on May 15, 2025. For now, the motion is granted as to the homicide victim's family and reserved as to Kohberger's family.
Okay.
So, which he kind of made that in, court, like he was saying where he would go with it, but at least, we know that they're going to have to be more detailed soon.
Right. Me too, Scarlett. And especially with a lot of the information we're getting through Steve's interviews.
Right.
None family. It's not like he's married or anything, but no, his family can be called.
Yeah.
It said that. Sorry, hold on. They're gonna have to disclose early on who's gonna be called for what purposes, and they'll basically figure it out from there.
Right.
Okay, so then, yeah, harlot. I know, yeah. It exactly, like I have a lot of sympathy in that aspect. I don't blame his mom for searching high and low for school records and teachers and anything to try to save her child's life. I get that.
And
Um,
I mean, I think a lot of times too, you see that the family members are called early, you know.
early on, yeah,
But when we
so that they can
watch,
attend.
but okay, when we watched Leilani's
Hmm.
trial, I remember I remember Paul being called towards the middle, right?
Yes.
I loved Paul. He was
Well,
hilarious.
yeah, I know. Al, was called first for Letitia.
Right?
Then he was able to be recalled. Same thing with George Anthony and Casey's. Called first, but was able to attend. But I'm noticing now we only get to see like half of the courtroom, at least in the footage we're going through. And I don't know because I don't see George and Cindy all of a sudden. They were there. Now I don't see them. And I'm like, I don't know but I know he's being called as the next witness. And I'm curious if they're excluding them for certain witnesses if they want to be in the courtroom for the majority, but there might be certain witnesses they cannot be in the courtroom because being called up next, it may overlap with their testimony.
Like a partial
Right.
sequester.
Correct. Exactly.
Right.
Okay, and I think this is like the only other one that we have. Every other one is just either like granting or whatever.
Yeah.
And this is the order on Kohberger's motion in limine regarding Riley Nolan and the touch and contact DNA. Dun dun dun. How many times have we gone over this one? But like, it's interesting. But like, they Anne does not want her. So
Mm-mm.
Kohberger moves in limine to exclude the testimony of Riley Nolan, the lab manager with the ISP Forensics Laboratory, who was disclosed by the state to testify about touch DNA and the transfer of DNA generally, and more specifically, that the DNA located on the knife sheath was more likely the result of a direct transfer. Kohberger argues that Miss Nolan's testimony, as well as many other testimony referencing the terms touch or contact DNA and or purporting to be an opinion about the means or mechanism how the DNA ended up on the knife sheath, is irrelevant or impermissible under IRE 403, and it fails to satisfy IRE 703. So oral argument was held, after which the court took the matter under advisement, and the court does not find exclusion of Miss Nolan's opinions is warranted. However, the court requests that the parties instruct their witnesses to avoid the use of terms like touch DNA, contact DNA, and trace DNA. So we have the standards and the facts. A knife sheath was recovered from the crime scene in this matter and swabbed for DNA. A sample of DNA, identified as Q1.1, was extracted from the swab by the Idaho State Police Forensics Lab. The DNA concentration was 0.168. Is that milligrams?
Yeah.
Because I know that with the capital G, it's different. I think it's milligrams to.
Yeah, it is milligrams.
Okay. It was subsequently tested using standard DNA STR, the short tandem repeat methods. The STR profile developed revealed that the DNA came from a single source male profile. The state disclosed Riley Nolan, the lab manager for the ISP lab, to testify to the operations of a forensic laboratory, the structure of the ISP lab, and the types of evidence in processes. Her disclosure further states Ms. Nolan will also testify to touch DNA and transfer of DNA. Specifically, Nolan will testify to the characteristics and nature of touch DNA, including how it is deposited and transferred to an item of evidence, the methods used to collect and preserve touch DNA samples from items of evidence, and the procedures and protocols used by forensic scientists to extract and analyze touch DNA, the manner in which results from touch DNA samples are interpreted, and the reliability of touch DNA and analysis and its acceptability in the field of forensic science. Nolan will also testify to the potential for DNA to transfer between an individual and an object, including the distinction between primary and secondary transfer, and the factors influencing the likelihood of transfer. So on February 17, 2025, the state submitted its rebuttal disclosures, including one from Ms. Nowlin. The focus of the second disclosure is touch and contact DNA and direct versus indirect transfer, including factors that can influence the transfer and persistence of DNA on an item. The final paragraph of her rebuttal disclosure states, many complicated factors can influence the likelihood of transfer of DNA and the persistence of the transferred DNA after deposition. Current DNA technology cannot conclusively answer the question of when DNA was deposited on an item or by what mechanism, i.e., direct or indirect transfer. It is possible the DNA detected on M2022 4843, item 1.1, resulted from secondary transfer. However, based on Nowlin's training and experience, it is her opinion, given the quantity of DNA detected on the item 1.1, which is again 0.168 nanograms to, I don't know what UL is. What is something liters? I'm not sure what the UL is. And given the DNA profile obtained is single source, it is more likely the result of a direct transfer. So it has the analysis. You want to do the analysis?
Kohberger's argument is threefold. Oh, wait. Yeah, I got it right. Okay. First, he seeks to exclude any testimony by Miss Nowlin regarding when and how the DNA found on the knife sheath was transferred there, arguing it conflicts with the current consensus with the forensic science community, is outside her expertise, and is speculative. Second, he argues generally that use of the terms touch and contact DNA should be prohibited at trial as misleading, confusing, and unfairly prejudicial. Finally, he argues that Ms. Nowlin's rebuttal opinions must be stricken as improper rebuttal. Each will be addressed in turn. A. Ms. Nowlin may offer disclosed testimony about DNA transfer, and scientific, technical, or other specialized knowledge will assist the trier of fact to understand the evidence or to determine a fact and issue. A witness qualified as an expert by knowledge, skill, experience, training, or education may testify thereto in the form of an opinion or otherwise. To determine whether expert testimony is admissible, the district court must consider two factors. First, given expert opinion testimony, a witness must be qualified as an expert on the matter at hand. Second, once the witness is qualified as an expert, the trial court must determine whether the expert's opinion testimony will assist the trier of fact in understanding the evidence. Expert opinion, which is speculative, conclusory, or unsubstantiated by the facts in the record, is of no assistance to the jury in rendering its verdict, and therefore is inadmissible as an evidence. 1. Ms. Nowlin is sufficiently qualified. Whether a witness is sufficiently qualified as an expert is a matter largely within the discretion of the trial court. In arguing Ms. Nowlin is not qualified to render an opinion on DNA transfer, defendant contends that within the forensic community there is a consensus that only experts specially trained in DNA transfer are qualified to render such an opinion. He asserts that as a lab analyst, Ms. Nowlin does not have the expertise to proffer an opinion in this case as to how the DNA was transferred to the sheath. To establish this consensus, Kohberger relies on two forensic science publications regarding DNA transfer, both of which recommended that DNA analysts should avoid rendering opinions regarding DNA transfer absent specialized training. The first article, authored by 5 forensic scientists in 2019, discusses what we know about DNA transfer and the associated elements of DNA persistence, prevalence, and recovery, sometimes referred to as DNA TPPR. Notably, the journal in which the article appears, Forensic Science International Genetics, is an international one, and each of the 5 scientists are from outside the US. The second article is a report published in May of 2024 by a group of individuals referred to as the Expert Working Group, EWG, on Human Factors and Forensic DNA. Oh, that was that one
Mm-hmm.
that they told you to look at. Okay.
Yep.
The express purpose for this report was sponsored by the U.S. Department of Commerce's National Institute of Justice Office of Investigative and Forensic Sciences, was to conduct a scientific assessment of the effects of human factors on forensic DNA interpretation, with the goal
Sorry,
to
I read that. Kohberger did not provide this article to the court. The court obtained it from the web.
people are getting a
And,
little
you
shade.
know, it obtained the 19-page portion of the article from the web, including the abstract, which contained the quote relied upon by Kohberger. So the web version does not reference the page number of the published articles, but it is paginated as page 1 through 19, and the citations are here. So I just thought it was funny.
It is funny. Uh, um, so recommending strategies for improving the production, evaluation, communication of DNA results. So this goes on with the quotes. This report goes on to note that an expert rarely, if ever, has all the information needed to perform a robust, balanced, and transparent evaluation of biological results regarding transfer or specific activities on the witness stand. Consequently, the report advanced the following recommendation. Recommendation 7.1. DNA analysts should not opine about the possibility or probability of direct or indirect transfer having occurred in the case. Based on these two articles, Kohberger posits that Miss Nallen, as a quote typical lab analyst unquote, is not qualified to substitute her judgment in the face of the weight of the forensics community's agreement that the science and literature does not support any analyst testifying about the when and how of transfer. The state responds that Kohberger's argument is both legally and factually flawed. The legal flaw is that it misapprehends the appropriate standards to determine admissibility of an expert opinion. The state asserts that the standard is not the consensus of the scientific community, but on whether her knowledge will assist the trier of fact. The factual flaw is Kohberger's failure to mention the lack of consensus in the EWG report regarding the recommendation. Notes. Yeah, okay. The court finds Ms. Nallen is sufficiently qualified to render her opinion on DNA transfer despite her lack of specialization in DNA TPPR. The test for determining whether a witness is qualified as an expert under Idaho law is not rigid. A qualified expert is one who possesses knowledge, skill, experience, training, or education. This language is intended to provide wide latitude in how a witness may qualify as an expert. In situations where a witness has general expertise in a broad subject but is not a specialist in the specific aspect of that subject, that is pertinent in this case. Most courts conclude that general knowledge can be sufficient to qualify the witness as an expert. This is because the issue under Rule 702 is simply whether the testimony of a witness with only a general background is reasonably likely to help the trier of fact, not whether a specialist would be preferable. Differences in expertise bear chiefly on the weight to be assigned to the testimony by the trier of fact, not in admissibility. It's quoting another case law. So it says, according to her affidavit, Ms. Nallen is currently qualified and proficiency tested as a DNA analyst and has been so qualified for 20 years. The affidavit of Nallen reveals that she's worked as a forensic scientist in biology DNA. Do you want me to read that part?
Where?
Keep going. You're right there. You're good. We're right there. She worked as a forensic scientist in biology DNA at the Idaho State Police Forensic Services Laboratory for 11 years before becoming its manager. She is certified by the American Board of Criminalistics and as a molecular biology fellow. She's a member of 4 professional organizations in the forensics field. She has taught courses to law enforcement and medical personnel on DNA in the forensics context and has published scholarly articles on the subject. Based on her professional experience in the forensic DNA field, Ms. Nallen at the very least possesses the general expertise to opine to matters of DNA transfer. Given her general expertise, any lack of specialized DNA TPPR training, as advocated by Kohberger's authorities, goes to the weight of her testimony, not its admissibility. Further, in challenging her qualifications, Kohberger is seeking to hold Miss Nallen to an aspirational standard of expertise in the forensic field that is, for now, is nothing more than a recommendation, and a disputed one at that, within a segment of the forensic science community. Not only do Kohberger's articles fail to establish any established standard of qualification, Ms. Nallen disputes that there is a consensus in the forensic DNA community and that the DNA lab analysts should not have opined as to DNA TPPR. She points out that not only were there dissenters to the EWG's recommendation, there is a divide in the forensic DNA community on this specific topic. So more importantly, Idaho has not adopted the standard for admissibility set forth in Daubert, which considers inter alia whether the expert's theory is commonly agreed upon or generally accepted. Therefore, whether there is a general consensus supporting Ms. Nallen's opinion or not is irrelevant to its admissibility.
Defendant has not established a scientific consensus in the United States outside of the EWG group, which is comprised of only 25 individuals, only some of which are forensic scientists. Sorry, I love the little notes at the bottom.
Me too. I feel like it's like Hitler's like snark.
Yeah.
Notably absent from either party's briefing are court cases discussing the issue of whether DNA analysts are qualified to testify to DNA transfer. A review of case law reveals that such opinions are offered by DNA experts without dispute over qualifications. It appears only one court, a military court, has squarely addressed the issue and declined to find the DNA analyst was unqualified to render testimony. In doing so, the court rejected the notion that DNA transference was a separate science from DNA extraction and analysis, and therefore the expert in DNA was qualified to testify to transfer. In sum, given the liberal standard for qualifying a witness, Ms. Nallen's experience and training in the area of forensic analysis of DNA generally, the current divide in the forensic community regarding whether lab analysts are qualified to testify to DNA transfer, and the lack of jurisprudence on the matter, the court declines to find that Ms. Nallen lacks the qualifications necessary to provide an opinion on DNA transfer in this case. Kohberger's challenges to her qualifications affects simply the weight to be afforded her testimony. Ms. Nallen's testimony will assist the trier of fact. Having determined Ms. Nallen is qualified as an expert, the court must determine whether her testimony will assist the trier of fact in understanding the evidence. This condition goes primarily to relevance. One aspect of relevancy is whether the proffered expert testimony is sufficiently tied to the facts of the case, such as the testimony will aid the jury in resolving a factual dispute. An expert's opinion that is speculative or unsubstantiated by facts in the record is inadmissible because it would not assist the trier of fact. If the expert's testimony is competent and relevant, it may be admissible. The weight given to the testimony is left to the trier of fact. Kohberger argues Ms. Nallen's rebuttal opinion that the DNA detected on Q1.1 quote, is more likely the result of a direct transfer, unquote, is speculative because it offers possibilities that are not based on substantial scientific principles. The state responds that Ms. Nallen's rebuttal disclosure sufficiently explains the scientific principles underpinning her opinion and the reasons for her opinion. In addition, the fact that Ms. Nallen cannot testify conclusively as to when and how the DNA arrived on the knife sheath does not, according to the state, render her opinion speculative or otherwise unhelpful to the jury. The court finds Miss Nallen has identified an adequate scientific basis for her opinion. Her rebuttal disclosure reveals that she will discuss the difference between single source DNA profiles and mixtures, concepts pertaining to direct and secondary transfers of DNA, and the variables that can influence the transfer, persistence, and recovery of DNA. In fact, this discussion closely mirrors the TPPR DNA principles advocated in the articles cited by Kohberger. While Kohberger may not think Ms. Nallen is adequately qualified to offer an opinion on DNA TPPR, the this does not render what does it mean?
It's a typo.
Okay, this does not render her opinion devoid of scientific principles. In addition, although Ms. Nallen admittedly cannot testify conclusively as to whether the DNA was transferred to the sheath by direct contact rather than indirect, this does not render her opinion speculative. Testimony is speculative when it theorizes about a matter as to which evidence is not sufficient for certain knowledge. An opinion that is speculative suggests only possibilities and may be properly excluded since the opinion would not assist the trier of fact. So this is quoting state law, and it says Ms. Nallen's opinion does not, or sorry, Ms. Nallen's opinion does more than suggest possibility. She states that while it is possible the DNA on the knife sheath was from secondary transfer, it is more likely the result of direct transfer, given that one, the DNA was a single source profile, and two, there was a 0.0168 nanogram of DNA detected on the sheath.
Which is a
As-
lot, apparently. A decent amount.
Right. As the state points out, an expert may testify to a likely opinion, particularly where the expert acknowledges the limitation of such opinion. It gives case law there. And then Ms. Nallen's opinion is no different. She will testify that based on scientific principles regarding DNA transfers and her observations of the quantity of DNA and the type of profile found on the knife sheath, it was more likely a direct transfer rather than a secondary transfer. Further, the fact that she admittedly cannot render a conclusive opinion about how the DNA arrived on the knife sheath, and it is possible it was through secondary transfer, does not render her opinion inadmissible. It is simply an acknowledged limit to her opinion. Neither party has cited to case law discussing the admissibility of expert opinions on DNA transfer. However, the cases reviewed by the court indicate that Ms. Nallen's opinion is acceptable despite her inability to reach a definitive conclusion. So it goes through case law and it says, based on okay, sorry, that's state versus glass.
That's still them. Okay.
Yeah. Okay, so these cases demonstrated that it's not outside the permissible bounds of expert testimony to opine as to the likelihood of DNA transfer, and in fact, such opinion can be crucial to putting the DNA evidence into context. Indeed, Ms. Nallen is offering the very opinion that the Glass court found lacking, the correlation between the amount of DNA deposited and the likelihood it was transferred by direct or indirect contact. This will aid the jury in understanding the evidence. Consequently, her opinions will not be excluded. B.
Mhm.
Oh, do you want to go for it or do you want me to?
B says misleading DNA labels are to be avoided. So Kohberger next argues that the term touch or contact DNA should be excluded under Iowa because it mislead the jury into inferring that the depositor of DNA actually touched the object on which it was found. The state only addresses the term touch DNA and argues it should be allowed because it's a common term within the field. Further, the state points out that it will be clear to the jury from Ms. Nallen's testimony that touch DNA is a term used only to distinguish that type of DNA from other kinds of DNA. Relevant evidence may be excluded, quote, if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, or misleading the jury, or by considerations of undue delay, waste of time, or needless presentation of cumulative evidence. The issue here is whether the word touch is prejudicial, as it implies that the DNA was transferred via touch. I'm just going to pause for a second. So a lot of these motion in limines back and forth, we've read this, right? And so in a lot of Anne's arguments, she has put forward that it's, undue delay, waste of time, needless presentation. It's going to bias the jury, prejudice the jury. And so it constantly goes back to the relevant evidence may be excluded if, X, Y, and Z. But a lot of times, no, it's just the argument she's making. And it outweighs its substantial value, always usually is outweighing it. But she tries, and it says touch DNA is a shorthand reference to the epithelial or skin cells that may be left behind on an object when it is touched or comes into contact with the skin. We have case law. So it is a common term in the DNA forensics field. So the affirmative noun, indeed scientific and legal literature, as well as case law, is replete with references to touch DNA, including the 2 articles relied upon by Kohberger. In fact, Kohberger's own expert, Dr. Ruth Ballard, references touch DNA in her report. Oh, however, as one of Kohberger's article observes, the term touch can be misleading, as it implies a specific mode of action and, to some degree, also a type of biological source. Instead, the author suggests using the term trace DNA, which is less descriptive. Ms. Nallen, however, disagrees that trace DNA is a better term, stating, quote, "The term trace DNA implies amount. The word trace is defined as a very small amount and is used in the scientific literature when describing evidence samples with low amounts of DNA that do not yield a profile or only a partial profile. I would not be willing to use that term, and it would be inappropriate to apply that term to the DNA on the knife sheath because a trace amount is not what I detected on item 1.1, and referring to it as trace DNA would be misleading to the trier of fact, which is, again, going to note it is a substantial amount of DNA, guys, that they got on that sheath. So given the ubiquitous of the term, the ubiquitousness, sorry, God.
I would say, remember we watched that Law and Crime special where they had the DNA analyst in there, and she even said that was a lot of DNA.
It was a
single
They
source.
had way more than that, the machine to detect it. Way too
Than
much.
they needed, yeah.
Yes, way too much. So given the ubiquitousness of the term touch DNA is not only the forensic DNA field, but in the legal and scientific field as well, the court is unwilling to prohibit the term. I'm happy.
Yeah, me too.
So there is too great a risk that a witness or counsel will inadvertently refer to the term out of habit, potentially giving rise to a motion for a mistrial for violation of a court order. Moreover, the court is not concerned that the jury will be misled, given that both parties have DNA experts who can easily disabuse the jury of any mistake in correlating touch DNA with actual touching. That said, the court asks the counsel avoid the use of the terms as much as possible so that any potential confusion can be bypassed. To this end, the parties are instructed to submit a mutually agreeable instruction to provide to the jury in case the terms are inadvertently used. If a witness uses the term, opposing counsel can examine the witness about the broader meaning of the term within the forensic community, and the instruction may be given at that time, which I think is fair. That's fair.
Yeah.
Ms. Nallen's rebuttal opinions are proper, so Kohberger's final argument is that Ms. Nallen's anticipated rebuttal testimony is improper because it does not respond to any opinion by Kohberger's own expert regarding the DNA transfer. The court does not agree. Quote, rebuttal evidence is evidence that explains, repels, counteracts, or disproves evidence which has been introduced by or on behalf of the adverse party. As the state notes, Kohberger's DNA expert, Ruth Ballard, acknowledges, quote, there is good support that Mr. Kohberger's DNA was found on item 1.1, a swab from the knife sheath. However, her report indicates she will inform the jury that DNA on an item could be the result of indirect transfer from skin cell DNA. The disclosure implies the jury should give little weight to Kohberger's DNA at the crime scene because it could just mean Kohberger's DNA was nothing more than innocuously shed skin cells or DNA prior to the crime, and the knife sheath could, quote, be picked up and transported to a crime scene by someone else who sheds no DNA on it. She also opines that the DNA was found in a location that suggests it would persist for a long time because it was protected. So, given Dr. Ballard's anticipated testimony, Mrs. Nallen's rebuttal is proper. She will discuss the process of primary and secondary transfer, the variables affecting transfer and persistence, and why she is the opinion that the DNA on the knife sheath was more likely the result of a direct transfer. Of course, if Dr. Ballard limits her testimony on the stand, the court can reconsider the scope of Miss Nallen's rebuttal. However, based on Dr. Ballard's report, Miss Nallen's anticipated rebuttal is appropriate. Order based on the foregoing, Kohberger's motion in limine regarding Riley Nallen and the reference to touch and contact DNA is granted in part and denied in part.
Boom.
Woo!
Oof. We did them all.
We did them all. And here I will pull this up because you said that people were asking.
Oh yeah. I'm sorry, I can't remember who asked in chat about Kohberger's family statement.
So this
This
is
came
back,
from the lawyer, yeah.
January 1st, 2023. And it was a press release from Kohberger's family. And it's Kohberger family statement. It says, first and foremost, we care deeply for the 4 families who have lost their precious children. There are no words that can adequately express the sadness we feel, and we pray each day for them. We will continue to let the legal process unfold, and as a family, we will love and support our son and brother. We have fully cooperated with law enforcement agencies in an attempt to seek the truth and promote his presumption of innocence rather than judge unknown facts and make erroneous assumptions. We respect privacy in this matter as our family and the family suffering loss can move forward through the legal process. Sincerely, and this is Jason Allen Labar, which is the Chief Public Defender, counsel for Kohberger at the time. Which I believe that statement. I think that you have to be very careful because when you are on the accused family side, everything, like what could you, I think that was appropriately stated. I think it acknowledged both sides and didn't, our son's innocent versus highlighting the presumed innocence, and they're gonna support their son while respecting the victims' families. Like, now granted, it was probably typed out just by the lawyer themselves, but it was done appropriately in my opinion.
Yeah, I agree. I think it's respectful.
Oh my lord. It's getting really intense, and it's not going to slow down.
I know. I was thinking because we have like March 15th is supposed to be pre-trial.
Yes.
And
no, May 15th.
Oh, sorry, May 15th.
Yeah.
And I was looking at the case summary, just kind of seeing like if we might get anything trickling in. But there's like a notice of compliance. It's everything we've already seen. So yeah, we have everything that's out there.
We are officially caught up. Yeah.
Yeah.
I'm obsessed. It seems okay. So for all of the Kohbergers, and I acknowledge, hey, you could have questions. I even have questions tonight regarding certain things I've found out, but it does not at all affect what's come out against Bryan. That's the part I'm going to get hung up on. Hey, I see, even though I don't want to say I see a contradiction, because here's the truth. None of that came out through the legal process. If it came out through the legal process and all of a sudden we're seeing contradictions, that's a problem. This is why you can't trust interviews or sources, and even something, because I don't know if you guys remember in Steve's interview with DTS, and he had said he was close enough to touch their Wi-Fi. He admitted he may have misspoke based on something he had read, and that is to be expected. Their emotions and overload of information. It was chaos, and so all I'm saying is you cannot rely on anything that isn't black and white in these documents. So if I look at it in that sense, okay, no, I shouldn't have believed anything I heard prior. But yeah, it still makes me go, well, if he spoke to Hunter directly, he would know. That's not even something he would just hear versus he would speak to Hunter directly. But I don't know. But even acknowledging questions regarding that, it plays no role in everything being presented against Bryan. And it's a lot. And everything Anne is arguing doesn't point to anyone other than him. And I know that they don't have to. They just have to create reasonable doubt. But I think she's pushing for technicalities, and she's hoping a plea deal will be at least offered. I'm not saying that they would take the plea deal, but she's pushing to get at least a plea deal on the table offered.
Yeah, I could see that. I mean, I don't think. Do you think that she would expect it at this point, though? I mean, honestly.
I think she would expect a plea?
Yeah, at this point.
I think yes. I think she's fighting tooth and nail and making issues. And I think the truth is that when you look at public perception, there's a huge number of people who are screaming his innocence. And I can imagine that is a little bit nerve-wracking, right? And I think Anne knows that, and she plays on that. And so, yeah, I think that if she fights enough, that they may at least offer, so that they, I think that there's a possibility. I think she wants the option. She wants to know, because Judge Hippler isn't playing this game. And as they get closer, it's only getting tighter and tighter. And nope, this is think about the whole fucking genealogy, right? How 2 years fighting that just for it to finally the same thing that we could have agreed on day one, And I think that now that the orders are being put in place, and no more funny business now. There's not much room for her to fuck around with.
Yeah, but I found it interesting that was it the autism order that we went through where it stated that Bryan believes he'll be found not guilty.
Yeah.
I can understand maybe where Anne would want a plea on the table, but I don't think that's what he would take.
I don't know if Anne would even advise that he would take it, but I think Anne wants that options as they're getting closer. I didn't think that before. I think that more recently.
Yeah.
Especially seeing in the last 2 hearings, you could see I don't want to say she's off her game, but she wasn't as sharp as she's very, when Judge Hippler, because Judge Hippler goes back and forth with her, and I love that. Not just her, he very much you don't see that all the time. Judges communicating and asking their own questions and throwing out their own potential, you don't see that all the time. And so I love that Judge Hippler does that. And I've seen her really pause a lot and have to think about what she's going to say versus it just naturally coming right out. And she'll be like, well, no, I'm not saying that the court is going to do that. What I am saying, I'm seeing her hesitate. And I feel like that's because there's no more room left. She's getting more narrow and narrow and narrow. And at first she had all this space to flail her arms. And now the walls are coming in and she's not having that room anymore. And I think she feels that. She feels that heat. And I think she at least wants that option to be there. Whether they take it or not is a whole nother discussion. but I think she wants that option. But the more that they don't present that option, it's becoming very obvious they are confident in their case. Harlot
Yeah.
says, I don't get why they put that Bethany said Xana and Ethan got home around 1:45 in the PCA when they're now saying they weren't home yet at 2 a.m. Huh? It's a great point. They did. That is what it stated. Because they were all home. Yeah. Absolutely, Nini. Absolutely, Kohberger could have done this alone. It doesn't take that long at all. Honestly, like, I understand, hey, we're dealing with a tight time frame. Absolutely. But to move through the house and to kill 4 people with that weapon specifically,
Yeah.
really doesn't take long.
And you guys gotta remember, he ran a mile in 6 minutes, like from his Strava data. Like he definitely had the cardio and endurance. Like,
and he planned it out. You guys, based on the evidence, he had been planning this prior to ever picking his victims. This was something he studied. He went 23 times prior. This is like he went in knowing exactly what he was going to do. This wasn't an impulsive decision. It may have been impulsive on that specific night, maybe, but he knew, he had his intent, and that helps as far as the time frame for me.
yeah. I think it's going to be really telling too, to see what they could come up with search histories too, you know?
Yeah. Well, I really want to know. Oh, Nini, we have an entire playlist where we started back from the very beginning if you want to catch up. But it's going to be a trial that's going to be historical. I could just feel it, either way, because you have such like a quadruple homicide, like it's such a huge trial. It's going to be fascinating to observe. But he was capable. Absolutely, without a doubt. I would again go back to the Apple River stabbings. You could watch it on video. The damage that was done to numerous victims in such a short, like, it happens right in front of your eyes. You're watching the video.
That
And
was like less than a minute, right?
that was seconds, Shay. Seconds.
Yeah, that was wild.
And it was like, holy shit. Like, you didn't even the
You didn't even
people
see the
who
knife.
you didn't even see the knife. The people who were there didn't even realize what was happening. And
Until there was blood in people's
yes,
organs. Yeah, it was gross.
yes, it was like 5 or 6 kids. And yep, exactly, Harlot. And that's what I'm saying. When you're dealing with a specific weapon, okay. And again, people aren't accounting for this was a K-bar knife. This the damage that is done. Oh no, it wouldn't have taken a long time at all.
Yeah.
Yes, exactly, Lucy Day. The Apple River happened so fast you couldn't even tell it happened until the minute after. Right.
Right.
And
I think
even
until
after
they
it
saw the
happened,
blood, they were
right,
like, where's this coming from?
and they still didn't know what the fuck happened, right? It was just the injury, something serious had happened. Yeah, that knife is made to inflict serious damage, and the length of it, people, my God, the length of it. I've showed you guys the photos of Ashley Banfield holding it up. It's the size of her fucking head.
Yeah. And all 4 of these kids were intoxicated, you know? I mean, 2 were definitely, in my opinion, asleep based on what we know.
Well, and don't forget what Steve said. 2 of the victims essentially would have drowned. And I believe that is Maddie and Ethan.
Ethan, yeah.
But I'm still hung up a bit on.
Dylan running by and seeing them. I know.
Because I said from the beginning, I truly struggled with her passing that hallway and not looking. I've always said that made no sense, but I didn't expect to hear she saw her then. I didn't expect that.
See, and that's why I want to know what she talked to Bethany about. Did she tell her she saw her at that point, or did she not
Absolutely.
remember it till the next day as she's going through recounting everything? Like, I'm really curious. But I mean, I'm sure it was awfully scary to even fathom that that could happen.
Well, I'm a big person on energy, like, and I 100% believe the energy must have been, if she walked past that right after, minutes after,
Hmm.
there,
Yeah, she
the
did,
energy
Scarlett.
must have been there.
Yeah.
Yes. And she convinced herself she was drunk, passed out, which,
But she did state that she has had a history of having lucid dreams, nightmares, and things. Like, I guess I can see, like, you're like, is my mind playing tricks on me? Like, that can't be, you know?
yeah, honestly, I think you would have to really know people's personalities because everyone is different. And what I could say I would do is completely fucking different than what someone else would do. Everyone has, like, who knows, this girl could have already struggled with serious anxiety, serious that, who freaking knows? Everyone is so different. I know hypochondriacs, like people who the moment that you have a sniffle, like they believe they're dying, like straight up. That's just their personality. So I don't know what Dylan's personality is, and that's why I really look forward to, I need to see them on the stand. I cannot do just transcript. I cannot do just audio because there's stuff that you're going to pick up observing them. You know what I mean?
Right. Yeah. I mean, and when they did the cast report, of course, their phones would be included in that.
Yes.
So they
Yes.
confirmed every move they made too.
Every move. Yeah. And so anyone who's saying, oh, we're going to clean up, which I know that must be the talk, especially with evidence of a cleanup, if that was, which again could be something as simple as blood was wiped in one spot, like not wiped clean versus just one wipe. Who knows? Um,
Well, you remember, Kathy Mabutt did say that the, how did she say it? The crime scenes were contained to the rooms.
yes.
So that was really early on we heard that. And I know she said some wild stuff, but that's always kind of held on to my mind.
Which would be just so crazy
Hmm.
to think that there was nothing, especially finding out Kaylee had more injuries.
No.
And I'm really
Oh,
curious with second weapon, you guys, your fist can be a weapon. A clicker can be a weapon. Like anything can be a weapon. Just keep that in mind. Ah, but man, it's just a lot to take in.
the booties on the booties. Yeah, I think the booties on booties can happen.
Crime scenes contained to the rooms makes me think that Maddie's room was never. See, when I heard her say that, I took that as all victims were in the rooms. It didn't. Nothing. No victim was outside of the rooms.
Jeff, what did you think about hearing that the Dylan and Bethany saw Xana, specifically Dylan, that night? Because a lot of us had thought that maybe that door was shut. I'm really curious what Jeff thinks about that.
Well, we were told that, not from documents. We were told though from the sources and the interviews.
Hmm.
Yeah, I took it either as no victims or no blood left the rooms.
Yeah.
He could have. He could have. Um. Oh my gosh.
Oh, wow, Jeff. Oh.
Oh. Well, here's the thing, Jeff. She specifically said the feet was closer towards the door and her head was facing towards the wall. So even with a blanket, at least the head and or at least feet had to have been visible to determine the head would have been.
Yeah. But you could still, yeah, technically interesting.
Oh, jeez.
Oh my
But
God.
that's true. That's true, and that's why I would like to know how close was Xana to that wall. But it
Well,
was
I think that
somewhat
was
on a slant.
Ethan.
You think it was more Ethan?
Yeah, because that's where the bed was against.
Yeah.
According to the pictures that we had seen from like of Xana and the way her room was set up, like in my opinion, it would have been Ethan's head to that headboard is against that wall. And when you look at those mattresses coming
Yes.
out,
Yes.
that it looked like Ethan's profile.
Yeah.
Oh, Jeff, that's heartbreaking. Oh, but hey, that's not a bad theory though. Maybe, maybe.
Yeah, I don't see them going in and shaking her at all because Ethan would have been evident at that point. Um, and we now know from the documents, no, they did not make. The only one who would have made any entry towards the room was Hunter.
Yeah, I was just shocked that the door was open, like, because I
I
always kind
am
of thought
shocked.
that.
Well, yeah, that's what we've heard up until now, but it
But
makes more sense now to why Xana specifically unconscious. She was on the floor, visible.
and to touch less doors, remember?
Mm-hmm.
Because if he kept the slider open, it's to limit the amount of contact on the doors.
No FOS. But the only one who would have been visible from that hallway would have been Xana.
Mm. No,
Which,
not Ethan. It was Hunter. Hunter went and grabbed a knife whenever he came over to check on the girls. He ran to the kitchen to get a knife.
well, and it makes a little bit more sense that Dylan, Bethany, Ethan, all underage. They're all underage, and they cops were there often, and the concern to call unless they for sure knew something was wrong, because they could have been prevented from graduating. The others could have got charged.
Yeah. Well, girl, I need to get off. 'Cause I gotta get up early.
I
But
know
I
it's been
thank you
almost
for
4 hours.
having me.
No, thank you for coming on, and we'll do our next episode, soon. And I'm shook. I need to digest all this information and think about it.
Yeah. Also, I'll
I
go see if I
know.
could find some of the theories going on out there.
Oh yeah, because we still have to do our theory. Oh my God. Honestly, I'm not prepared to go out and look at what the Kohbergers are saying, but we need to discuss it because I like to consider everything and try to debunk what I can and see
Mhm.
what's left over. And that's what I feel like, because now we're officially caught up with everything. So, but every time we catch up, something else comes out. So we have to keep going. But I really want to do what's going on with like the Kohbergers. What are people saying as of now, and where are they sitting? Because I think that would be a very good discussion.
For sure, for sure.
All right. Well, thanks everyone for hanging out. Thank you, Shay, and
Thank
we
you.
will talk to you guys soon. I'll let you guys know what day we decide, and we'll see you guys back soon enough.
Bye.
Good night.